Okay. Thank you. Welcome everybody to the Abbey of Neumünster. Sorry for the pronunciation. I am French and I'm not sure that it's a good way to pronounce the name of the Abbey. On behalf of the Center for Law and Economics of Sport of Limoges, I want to say thank you everybody to be here, both in person here in the room in the Abbey and online, because this conference is live streamed on our YouTube channel. It's a pleasure to be here, and an honor also to have many people involved with us on the program. Thank you very much to all our partners that helped us a lot to organize and build the conference on a very short notice. I want to say thank you, to the University of Luxembourg, with which we have been organizing this event, but also to the other academic partners. The University of Limoges, because we are linked to the University of Limoges, the Faculty of Law of the University of Rijeka in Croatia, the University College of Nordjylland, Sport&EU, the association Sport&EU, and also the International Association of Sports Economists. I would also like to give a special thanks to all the speakers that are here today to speak about this very interesting and accurate topic right now because of the debates that we have around the Super League case. So thank you very much for taking part in this conference and for your confidence. That few words been said, just a few reasons about the organization of this conference. As you all know, a couple of months ago, the Super League failed to be launched, but there is still a case pending to the European Court of Justice. So we were thinking that it was relevant and interesting to organize such a debate, academic debate with academic experts on these legal and economics aspects of the organization of football in Europe, but also more widely about the European sport model, because that's the real also problem behind all the debates we have right now. It is a really important topic for us at CDES, because we have been working on many studies on this topic around the years, and especially the last few years. We did two studies. The first one for the French Ministry of Sport, which was dedicated to the impact of the creation of closed leagues on domestic competitions. This study, unfortunately, has never been published by the French Ministry of Sport, so maybe one day. And the second study, which has been published, and you can find it on our website, and you have been distributing it here in the room, has been done for the French National Olympic Committee, and was dedicated to the European sport model. And to finally introduce this conference, I will ask to my colleagues, Nathalie Alaphilippe, a lawyer at CDES, and Jean-François Brocard, to give you the main and principal insights of these two works. So I call them on the stage, and you have the floor.
Hi everyone, I'm going to take the floor, Nathalie, if you don't mind. It's a pleasure for me to be here and to talk about this very important topic. The current organization of football is just an illustration of the institutionalization of sport, which originates in England at the end of the 19th century, when the first clubs and the first federations were created. The process of institutionalization was pretty long, and at the beginning of the 20th century, we could already observe some common pillars that appear to create an organization, a model of organization of sports in Europe. This model quickly widespread with the Commonwealth in the European ports, and a century later, of course, we already mentioned it, there's diversity according to countries, there's diversity according to sports, but still, we can definitely identify pillars that are able to define what we call the European model of sports. I'm going to focus on 4 pillars, but we could, of course, think of other ones. The first pillar is the monopoly of federations. The second pillar is the regulatory power of those federations, which have the power to regulate their sport. The third one is the membership of athletes in clubs, and the membership of those clubs in federations. And the fourth pillar is, of course, the organization of the competitions in this pyramidal system with the porosity between the different floors of the pyramid and the promotion and relegation phenomenon that illustrates how can those competitions be porous. This model, as I described, is facing challenges at the moment because it faces competition from the private commercial market on the top of this pyramid, but with a Super League, with a EuroLeague in basketball, but also at the bottom of the pyramid. That leads actors from the sports movement to wonder about the sustainability of the model and in turn about their own future. So that led CDES to be commissioned to conduct different studies that Christophe already mentioned, and that gave us, I want to say, expertise on the subject, and that's really why we're really happy to highlight today some findings of those studies with two perspectives, the economic perspective and the legal perspective with Nathalie. On an economic standpoint, sports is peculiar for two reasons. It's peculiar because it's a specific economic good, and it's also peculiar because it's a specific sector. And those two aspects should explain why sports deserve a specific treatment. First, sport is a specific economic good. One of the findings of our studies was that the European sports model, as I described, should be defended because sport is a very specific economic good. It should be considered as a collective good. That means that the impact of sport, the impact of producing sport, the impact of consuming sport cannot be all monetized. The impact on sport on health, the impact of sport, the sport consumption, the sport production, on citizenship, the impact on sport on socialization, it cannot be monetized. It's very difficult to evaluate it and to create revenues out of it. What the economic theory predicts when that's the case is that if you ask a private actor to produce sport, it's got to underproduce sport compared to the social optimum because it's going to focus on what's profitable in sport. In fact, if you want to take into account these social impacts of sport, you need to implement a broad cross-cutting policy, and that's only governments that can do it. You cannot ask private companies to do it because that's not going to be profitable for them. In this context, it's important also to mention and to present the principles of sport, and actually we think that it's the principle that constitutes sport as a collective good. Of course, the solidarity was already mentioned, and the solidarity, of course, is very important. We were always talking about the vertical solidarity, so coming from the top of the pyramid when it creates revenues to the bottom of the pyramid, and it's always important to remind that UEFA and IOC redistribute more than 95% of their revenues. The other principle, which is very important, is the talent development, which is the ability to develop talent. This is a very risky, very costly, middle to long-term investment that is not easy to tackle. The third principle that constitutes sport as a collective good is the territorial grid, the territorial coverage of sport. Sport should be offered to all peoples without distinction of social category, of solvency, of place of residence. And in fact, sport should be used by governments to plan their land use. The fourth principle is the integrity of the competitions, the mental and physical integrity of athletes, and those shouldn't be negotiable. Why is it so important to present those pillars, to present those principles when we want to defend, when we want to prove the reasoning behind the defense of such a model? That's because all the alternative models to what we call the European sports model proved inefficient in respecting these principles. We can mention the European initiatives EuroLeague, for example. ECA, a private company, is organizing 2 competitions, EuroLeague and Eurocup, and they hardly respect those principles. They do very little in respecting these principles. But we can also mention the North American leagues. They're always used as examples of how closed leagues are the solutions to all problems that sports faces. But if you look a little bit in detail, the NBA, the NFL, they don't do anything about solidarity. The best they do is called charity, and for Europeans, that's very far from what we call solidarity. They do pretty much nothing about integrity. When they decide to tackle integrity, that's only because this has implications on the revenues they can generate. Look at how they tackle doping, for example. Look at how they tackle betting. That's opportunistic, okay? And finally, NBA, NFL doesn't develop talent. They externalize this as well. They externalize, and they're really lucky because they get talent for pretty much free because of their university system, and because we, in Europe and in Africa, in other parts of the world, we still produce talent. But that's not generalizable, you know? Everybody cannot be the free rider in talent development, okay? Those leagues, those closed leagues that are like the dream in America, they cannot be imported in Europe for different reasons: tax, legal, social, maybe cultural reasons. And when they are important, when the closed league system is imported, like we have in EuroLeague, for example, it's an economic failure. Let's talk about it. It's important to remind that all the clubs that participate in the EuroLeague, actually, they lose money year in, year out. And some clubs actually lose a lot of money. Barcelona, look at the balance sheets. It's not the solution for sport. It never proved that it was the solution. UEFA and other competition organizers are criticized at the moment because of their little efforts in solidarity, their little consideration of sporting meritocracy, etc. But let's not forget that the current situation, which is definitely subject to critics and to debate, is just the outcome of 30 years of threats by big clubs of breakaway, which led UEFA to give them more money and to give them easier access to the competitions. So that's why a couple of colleagues of mine, Vandenborg, Beck, and Prince, they published a very interesting article in December 22, pretending that actually what should be illegal should be those threats made by big clubs, not the fact that UEFA is organizing the competition as a monopoly. The threats from big clubs should be made illegal. So that was my first argument. Sport is a very specific economic good. But the second argument is that sport is a very specific sector. It's a specific sector because athletes, clubs, they need competitors. Coca-Cola would be very happy to be the only provider of cola in the world. In sport, it's different. You need competitors. And if you seek revenues, you need good competitors. You don't only need competitors, you need good competitors, because you actually co-produce the competition that is eventually sold to the spectators, to the TV viewers, to the TV companies, etc., etc. And this product that you co-produce with your fellow opponents on the field is what is gonna be the product that's gonna generate revenues for you. One of the specific feature of this competition is gonna be the uncertainty of outcome. That's proven. There's many studies. If the competition is less and less uncertain, it creates less revenues. So that explains also why sport deserves a specific treatment when it comes to competition law, of course. And that's another reason why we believe it deserves a specific treatment. Those economic elements were presented just to highlight why we at CDES believe that this model should be defended, with just one condition: that the institutions still believe that sport is a collective good and still respect the principles that make sport a collective good. Of course, sport is not above the law, and there were many, many moments when law tried to tackle sport, and that's going to be Natalie to talk about it. Yeah.
Thank you. Yes? Okay. Hi, everyone. So yes, thank you, Jean-François, for setting the scene from an economic perspective, and let's now look at it from a legal perspective. I think it has been mentioned already, but everybody will agree that today football in Europe is at the heart of the debates on what we commonly refer to the European sport model. And with, of course, the very much awaited decision of the Court of Justice on the Super League case. So from a legal point of view, these debates, I think, lead us to address the question of the articulation of the legal system of sport and the European Union. Two legal systems that have been scrutinizing and testing each other, I'd say, since the creation of the EEC 66 years ago, with the pendulum swinging back and forth ever since, looking for a satisfactory position, satisfactory balance when they meet. The areas where the two legal systems meet vary in density, without this area being set in stone. And if I may, I will borrow a distinction made by Professor François Alaphilippe in 1987, who, for the record, with Professor Jean-Pierre Caracchio, created the Center for Law and Economics of Sport in 1978. So, when analyzing the relationship between law and sport, Professor François Alaphilippe identified three main zones of density, which I think can easily be transposed to the relationship between EU law and sport. With one, a zone of maximum sports density, where we find the rules of the game, and in principle outside the scope of EU law. A zone of what we call a minimum sports density, where sport and EU law rarely meet. For example, I don't think sport is really concerned with EU tax law and VAT. And then three, a more complex and heterogeneous zone, where the autonomy of the sporting organization in regulating and organizing their sport, faced with EU competition law, but also other important aspects of European law, such as, for example, prohibition of discrimination on grounds of nationality or freedom of movement of workers. So the question is, in this complex zone, where is the balancing point that would allow the two legal systems to live in harmony and in the sole interest of this very special good that Jean-François mentioned a moment ago, that is sport and the values it conveys. In order to illustrate this complex relationship, let's go back in time a little bit. So the early days. For a very long time, sport lived in a belief that because of its specific nature, its history, its anteriority, but also its global dimension, it had nothing to do with EU law. In short, the sport movement lived in kind of a bubble, according to which EU law was not applicable to sport. The first very hesitant meeting point between the two legal systems took place in the 70s with the very well-known judgments Walrave and Dona. Without EU institutions maybe not really knowing at the time how to deal with this new topic. For the Court of Justice, sport falls within the scope of EU law only insofar as it constitutes an economic activity. Well, distinction that the sport movement interpreted, at the time as a sporting exception in its favor and as giving it the right to bypass EU law. Hence, the rules on national team quotas or those on transfer fees for players at the end of their contract. For the latter, it should be mentioned that while transfer fees persisted at international level until the Bosman ruling, some member states, such as France, for example, had already abolished them. Then came the second period in the relationship between the two legal systems, going from what we often refer to as the Bosman Revolution to the Mecca Medina case. I think we can say that the Bosman ruling in 1995 turned everything upside down and shifted the pendulum very strongly in the direction of EU law, particularly in reaction to the fact that at this time, UEFA and FIFA did not appear to show a lot of interest in the European institution. The cases that followed, from De Liège to Simontenkov, extended the effects of the Bosman ruling to countries outside the EU through the cooperation and association agreements signed by the EU with third countries. In the end, since the rule of international sport organizations are intended to be universal, the effects of EU law on sport have practically been extended to the entire planet by the combined effect of the Bosman ruling together with the subsequent cases and the regulatory changes operated by international sport organizations with the view to global harmonization. Since Bosman, the European authorities have constantly extended the scope of application of EU law, gradually closer to the submission of sport to competition law. And finally, the culmination point, or the culmination of the swing in the direction of EU law, was reached with the Mecca Medina case in 2006, in which the Court of Justice decided that all sporting rules, even in the area of maximum sporting density, can fall within the scope of EU law, and competition law in particular. The third stage, which is up to this point the final stage, is marked by a real consideration of the specificity of sport. Indeed, the pendulum started to swing back the other way, led by politicians and not judges, with the adoption of Article 165, which explicitly requires that the specific nature of sport be recognized. The concept, obviously, of specificity of sport and its recognition by EU institutions did not start in 2007. The trigger being, without a doubt, the Bosman ruling. As early as 1997, the European Parliament recognized the specificity of sport and the autonomy of the sport movement, and constantly urged the European Court of Justice and the European Commission to respect this through its resolution. In the Helsinki report, the European Parliament states that the specificity of sport should be taken into account when applying the competition rules of the treaty to the sports sector. The European Council has also contributed to the promotion of the specificity of sport by, for example, reminding the European institution to consult sports associations when important issues relating to sport are concerned, or in taking a clear position in favor of preserving the core value of sport, such as solidarity, fairness of competition, and physical integrity of athletes in the Nice Declaration. The high point of recognition of the concept of specificity of sport is, of course, the white paper on sport in 2007, for the adoption of which consultation with all stakeholders played a key role. For example, in 2005, the Commission set up a consultation framework with the sport movement and the member states under the name the EU and Sport Matching Expectations, which main objective was to reinforce the promotion of European sport and its special characteristic in EU policy making, but also to achieve more legal clarity. And the European Commission continued to defend the concept of the specificity of sport after the adoption of the Article 165, as with its report on developing the European dimension in sport in 2011, in which the Commission clarifies the function of the specificity of sport. So there is therefore, and has been for a long time, a strong common will of the European institutions to take into consideration the specificity of sport. And it's then not surprising that at the time, the Mecca Medina judgment was seen both legally and politically as a major step backwards. However, despite the feeling of incomprehension this case generated, it must be recognized that not only have the European institutions since fully grasped the concept of the specificity of sport, but have integrated it perfectly into the decision-making process in matters of sport litigations. When European judges opt for the proportionality test in order to verify whether a sporting rule is compatible with the fundamental freedom or EU competition law, they choose to put forward the specificity of sport and permit the contested sporting rule to evade European law as long as it complies with this proportionality test. In a way, I think we can say that this test promotes, or at least facilitates, the establishment of a dialogue around the rules issued by sport institutions. And it gives them the chance to explain the objectives that these rules are supposed to achieve by proving their legitimacy, as well as the necessity and proportionality of the means implemented to achieve them. So although this mechanism is not a guarantee of optimal security for the sports movement, it's true that the case-by-case analysis does not make it possible to identify objective principles that would apply de facto to sporting rules. It remains that the recognition and use of the specificity of sport demonstrate that the European courts are aware of the special nature of sport and its values, which distinguish it from any other economic sector. With the forthcoming ruling on the Super League case, I think we can say we are at a tipping point. At a point where we may well see the pendulum stop at a position that is satisfactory for both EU law and the legal system of international sport organization, right in the middle of this very complex and heterogeneous area where the two legal systems should combine harmoniously, if possible. So, the purpose of this conference is, of course, to analyze and comment on current developments regarding the organization of football in Europe, to discuss why and how to preserve its specificities, but also to show that what is at stake goes far beyond football. It's time now for debate, and I wish you all a very, very nice conference. Thank you.
Yes, thank you very much, Nathalie and Jean-François. So now it's time for debates. Don't be afraid, there is no time for questions now, but as you have may seen on the program, you will have the possibility to ask questions to the participants of the two panels. To do so, we won't give you the mic, but we prefer you to send your questions by WhatsApp. There is a phone number on the paper, on the document. So if you want to ask a question to one of the panelists, please send it by WhatsApp and we will ask them for you. So now it's time to welcome the first panelists regarding the first topic that we are going to tackle. And this topic is clearly in links with what has been discussed so far, to analyze the benefits of the current organization of sport in Europe. And to discuss this key topic, I will just ask to Merin Khan, our moderator, to come on the stage. Welcome, Merin. Thank you very much for being here. And I will also ask the other panelists, Mr. Kenneth Korsen, Assistant Professor and Sports Business Strategist at the University College of Nordjylland, Mark Deutsch, Sports Sociologist and Professor, University of Brighton, and Mr. Jan Forrester, former Judge of the General Court of Justice of the European Union. Thank you very much, and Merin, you have the floor.
Okay, we are running a little bit late, but we do have an hour and then 15 minutes at the end for questions. And I would echo what Christoph says, because you don't want just someone like myself asking all the questions in this panel. I'll just declare my interest before we start. I have no dog in any of these fights, apart from the fact that I'm a football fan, and spent a short amount of time doing a little bit of sports journalism, but I gave it up because I didn't want to do what I loved for work. So I write about economics instead. And I also was in Brussels, so I've covered the ECJ as an institution, I've covered the EU's institutions, and I was also around to cover the sort of 2021 Super League moment, which seemed to pass very quickly, but now seems to be back in various forms. And I think my job is to try and encourage everyone into a debate. So the title is about the benefits of the European sports pyramid, but hopefully in that discussion we will also get to its shortcomings, because otherwise I wouldn't be a very good journalist if I was just allowing one side of the argument to prevail. Ian, I'm going to go straight to you. So Natalie laid out, a nice sort of potted history of the relationship between European sports and the legal systems of the EU, and how it sort of changed from maybe ignorance to ambivalence, and now the most important institution in this debate seems to be the European Court of Justice. So why don't we start with you sort of setting out what is the European sports pyramid, its definition, its meaning, its framework from an EU law perspective?
Okay, let me begin perhaps as in good opera. There's a happy party and then the evil witch turns up and says bad things and utters curses. In the nature of a health warning, I represented UEFA in the Bosman case, and there should be cries of shock and horror. That experience was formative, enormously important for me, not because it was difficult to describe the merits of the European sports model, but because of the lack of traction that those arguments had with the court. With the European sports model, it's obvious that we have an organization where the wealthiest have an interest in the continued prosperity of the weakest, where there is uncertainty, where the public see something that is always attractive, and where there are, so to speak, rules of the game. So it wasn't difficult to describe the merits of the European sports model. And in the Bosman case, to take that example, one of the things that was controversial was whether it was appropriate for Juventus, when it hires a talented player from a small Irish club or a small Scottish club, even if he's out of contract, to pay something to the club which discovered that young player. And Bosman had been badly treated, no question. Bosman is entitled to compensation, but, said UEFA, the system should not be compromised or condemned because it failed to deliver a good result for one player. That argument was made eloquently by lots of people, including myself, in French, and it was made passionately by dozens of sports ministers and other publicists who vociferously indicated to the court how strongly they felt. Advocate General Lentz and I used to do kind of reunions, Bosman 15 years on, Bosman 20 years on, and we would chat there saying, oh, you don't look a day older, and how have you been doing? And then he would say that he had never, ever in his life received as many passionate submissions on questions of policy as he did in the Bosman case. Now, the court in the Bosman case could have said, Mr. Bosman's entitled to compensation because his freedom of movement to seek work has been compromised, no doubt. But it decided to go further and to make findings of principle which were not required by the facts of Bosman. Now, you ask, what are the merits of the European sports model? Almost no one here has any doubt. We value the principles that everyone is familiar with. It's nice to look at. And the challenge will be, does the protection afforded by Article 165 of the treaty constitutionalize the status of the European sports model? Or does competition law, the evil witch, snarling and casting darts at people, does the evil witch of competition law take dominating control?
Do you think that question will be answered in a definitive sense when we get the final judgment on the ESL, which is imminent, and probably be, I think Natalie mentioned various turning points, but actually the moment where you can answer yes or no to that question?
That's, as they say, a good question. Advocate General Rantos produced a pretty fat opinion, which is strongly in favor of the European sports model. The question would be, if the court doesn't want to go that far, are there procedural guarantees, if that's the word, which could save the European sports model as well as the treaty? I may have said that badly. I did say it badly. When courts are faced, when the European Court, and my colleague José Luis is going to tell you, when the court is faced with a economically complex situation where the parties are saying, but we've always done it like this, it's perfectly reasonable, the court is very familiar with saying, no, European law primes. And there's lots of areas of daily life where one can see that. With this side on this side of the slope of history, some are not surprising. Equal pay between men and women. 60 years ago, 50 years ago, that was by no means established. So the risk is that Advocate General Rantos's opinion was too bold, but the possibility is, even if that is the feeling, it may be that procedure can be used as a way of finding the rival to the European sports model, on this occasion, not satisfied.
Thank you, I think I got that. But the second, I should also plug the second panel, which is going to be talking, I think, in a bit more depth about the legal specifics of the article and of the role of the court, and we'll come back to that. Kenneth, I want to go to you because the pyramid seems to rely on a trickle-down model, and in almost every other sphere of economics, trickle-down has been debunked, demystified, and proven not to be the panacea that people may have been holding it up as maybe 30 or 40 years ago. So why does trickle-down still work in the pyramid, and does it actually still work as a legitimate model for football?
Yeah, I mean, trickle-down is many things. I apologize for my voice. I have come to Luxembourg battling a flu in Denmark, and now I have a cold, so hopefully you can still hear what I'm saying. If you take the transfer market as one example of a trickle-down effect, when FC Barcelona sold Neymar to Paris Saint-Germain for an astronomical amount some years ago, I believe in 17, would Dortmund have sold Dembélé to Barcelona for that amount without the price tag on Neymar? So trickle down in that case is a trickle down effect on a few clubs, few specific clubs, and I think the beauty of the European sports model, of the UEFA model, is the solidarity. It's the cohesive situation where it goes all the way from the top to the very grassroots level. So UEFA gives a lot back, and there is a high level of interdependency. It's an open system. Even though you're from a small country like Denmark, you can still play in European competitions against, the mighty teams from the top 5 leagues. So I think UEFA gives a lot back to football, and it's also part of the European democratic model. But the interdependency is interesting for me. So players, they have a dependency on clubs. Clubs have a dependency on leagues. Leagues on federations. So with that being said, you can throw in the national teams in that equation. And I wrote in a book chapter about UEFA in a Routledge book for football business and management that came out in 2018, where I also interviewed some prominent UEFA people that, and that was back in 18, that I wouldn't be in fear of piracy leagues, because you've seen that threat quite often. But if you take the national teams and this interdependency, the branding of UEFA Champions League, for instance, why do you want to break out of something that is working so well? And that's one part. Another part is, over the course of the last decades, we have seen revenues for these top clubs that wanted to start the European Super League. They have skyrocketed. If you take from 2010 to 2020, big growth in terms of the number one clubs, in terms of revenue generation, but even more polarization. So the top 5 clubs, creating a bigger share of revenue generation, polarization in terms of an even bigger gap between number 20 in terms of revenue generation on the club side and number 1, just in the past 10 years.
I think we can come back to some of the transfer issues, because there's an argument that what you described at the beginning was just huge inflation of transfer fees, which we saw, I think, in this January. My own club, Chelsea, has spent over €500,000 in the last 6 months. Doesn't seem to have worked too well yet, but jury's out. Mark, we saw there was a very visceral fan reaction, at least in England, to the Super League. Is that a reflection of a public attachment to the European pyramid, or actually are fans just protecting their clubs and the status quo?
Normally I don't need a microphone. I've got a very loud voice. Yeah, I think the visceral reaction from fans, I think, indicates something quite distinct about the European model of sport, and what came out in those early addresses, particularly around solidarity, particularly about competition. What's really interesting, and I know we're at a conference about legal and economic aspects, and obviously I'm a sociologist, so I have to bring in the social, but the social is really important. What was talked about by the first speakers was about volunteerism, about engagement, about solidarity. These are all social aspects. A gentleman from Luxembourg University was talking about the volunteers when he was playing in the 1980s, and they were from different migratory backgrounds, but it's part of civil society. 24% of Europe volunteers, 6% of that is within sport. That underpins so much about what is the football pyramid. So when you talk about, the top is very heavy and it's definitely getting skewed, and the trickle down doesn't necessarily work as much as it did, but that voluntarism, that civil society at the bottom is really what makes sport specific, the specificity of sport. And it's very hard to qualify or quantify that social aspect. Jean-François mentioned about how you, from an economic point of view, how do you marketize that? It's really hard. So that's also what I would imagine comes from a legal and an economic perspective, is you can't sort of create those sort of objective rules, because it is emotion, it is engagement, it is belonging, it is just community, and that's something that is very particular about the European model of sport. And that's why there was that visceral reaction, because there is that emotional engagement to a collective experience. Very rarely does anywhere in Europe, even in churches or mosques or synagogues across the continent, is that communal engagement, that collective sort of emotional energy. And that's what football brings. And what was really interesting about that moment, particularly at Chelsea, was Britain was under lockdown. So people weren't allowed in the stadiums, but they still mobilized. They still hit the streets, because what is big recognition about this model is that solidarity that came out, which was about, and it comes back to an economic perspective that Jean-François mentioned, which is you have to have competition, because otherwise it's just a pointless, it's a pointless exercise. People won't watch it. People want the fact that 2 or 3 weeks ago in England, Everton, the bottom team, beat Arsenal, the top team. That creates that energy, that emotion, that volatility that actually leads people to go, oh, this is exciting. I want that thrill. I don't want, oh, they're going to win again. So that again breeds that emotion, and that's something that doesn't come across in some of the comments, which is that the volunteers, the fans, the people that turn up, that who actually underpin everything, that makes the model sustainable. Because yeah, we could extract everything, we could make money out of it, but who's going to be there in the future generations? It's those volunteers who put on the matches, who do the coaching. It's the fans who turn up and pay their money and watch, and that's what's really important about the model. But it's very hard to quantify or qualify.
Yeah, and just to comment a little bit about that, because totally agree that the cultural piece is very important here as well. The Danish FA did a study in 2018 where they tried to quantify what you're talking about here. So they ran a study and found out that out of this approximately 1,600 football clubs in Denmark, the volunteers of these clubs did work accounting for value of 9,000 full-time jobs, and this is a country of 5 to 6 million people. So I think, are we willing to sacrifice the centerpiece of European culture and just give that away to private equity investors? That's also an interesting question.
Ian, do you want to come in on this point?
Just a tiny comment prompted by my Bosman experience. The question was the indemnity that the big club pays to the little club when it hires a talented player. It was explained that I think it was something like 60% of the teams in the top 2 English first division, the top 2 divisions, made a loss on orthodox calculations, and that for them the possibility of a training indemnity was vital, and that was brushed aside. So we can convince ourselves that there's many good reasons for the European sporting model, and there are many obvious soft reasons in its favor, but the great challenge will be to write a judgment which is consistent with previous judgments and which doesn't cause great damage.
I want to go back to maybe the sociological, cultural point. So when we're talking about the alternative, I mean, let's be very clear, the alternative we're speaking about is a North American style closed system. And there seems to be a kind of a cultural pride that Europeans take in their own conception of fairness, which involves merit. So when you do well, you can win the league, like Leicester, and if you don't perform well, you will get relegated and suffer the financial and whatever other consequences of being relegated. But, I mean, I think Jean-François mentioned that the North American leagues are not competitive, but, you know, as a casual observer of the NFL and the NBA, basically different teams wins the championship. It's very rare you'll get the same team winning a championship 3 in a row. Okay, the LA Rams didn't even make the playoffs this year. LeBron might be the record goal scorer, shot scorer in the NBA, but his team's not doing particularly well. They have a draft system which helps those who are at the bottom or the worst performing have access to the top talent. That's the opposite of what happens probably in Europe, where those with the biggest deepest pockets get the access to the talent. There is competition in these leagues. There is an increasing number of European fans who watch these leagues because of the ability and accessibility of social media and the impact that US culture has. So we know that fans in Europe understand that there's an alternative model and they quite like it and they're quite invested in it and they have their own teams, etc. So why, I mean, I think, isn't there a stronger argument to be made for the European Football League that doesn't depend on this unique sense of competitiveness? Because actually we know that other rival alternatives are competitive in their own way. Anyone who wants to come in?
Let me start by a question. Which league in Europe has the highest average attendance level? Anyone?
I would guess it's the Bundesliga.
Bundesliga, correct. Bayern Munich, was Bayern Munich part of the European Super League? No German teams were part of the European Super League. And the German model is a model that proves, for me at least, to be sustainable. We live in 2023. There is a high focus on sustainability, social responsibility, all that stuff. They have high attendance levels. If you look at the sporting quality, just look at the teams that play still from Germany in the Champions League this year. They do extremely well in terms of what they call fan welfare maximization. So nurturing not only the sporting quality, but also the relationship to the fans. They have the 50+1 rule that protect against foreign ownership. That works well. And we have seen that when some teams and team owners have tried to fight that. Martin Kind in Hanover is one example. Fans would protest against that. And they have another thing that I think is very important. So we talk about competition here. And top football is characterized by high competition. But at the same time, we also have what is called co-opetition. So we are also dependent on our rivals. So when Borussia Dortmund was in financial problems, when FC Kaiserslautern was in financial problems, who came to rescue them? Mighty Bayern Munich. So the German model is, for me, a very solidary model. It's a model that works extremely well, also from top to bottom. I think we have a great sports model in Denmark. We also have a great football model in Denmark. 4% of our population is playing football in Denmark. Germany, much bigger country, 82 million people, but 80% of the population takes part in football. So numbers are also relative. So I think the German team staying out of the European Super League proves as a very strong label.
Mark, the German model is not the model replicated across different leagues. The English one is probably the one that it seems most iniquitous. What are the ways that can be fixed? Without thinking about changing ownership rules, and going full Bundesliga, because that doesn't seem to be anywhere near close to reality in England.
Well, I think part of this is always about political will. Like most things, it's whether, with one of the things that sort of characterized, Natalie mentioned about a pendulum swinging. Partly, I think there's always been what we've got to recognise that football and football governance is about competition as well. And I think that pendulum can swing. The Premier League came about because of basically a power battle between the Football Association and the Football League. There is a power battle between FIFA and UEFA and the clubs. There's always a power battle, and that's sometimes where the chinks come in, the breaks, maybe the opportunities, the businesses come in. But ultimately, that's then down to political will about bringing in the governance structures that will support that. And in Britain, for example, there was the Prime Minister before the last Prime Minister suggested about having a fan-led review, which became pretty much a governance review, which wasn't always just about fans. But actually bringing in the fans' perspective is one of those areas about recognising stakeholders. And I think that's the key thing here is when the discussions are made, when policy is made, even at a European level, who are the people that are consulted? Is it the commercial partners? Is it the federations? Is it the clubs? Maybe even FIFPro and the players. But actually, what about the fans? What about the volunteers? All those people who effectively are keeping this mighty pyramid standing up. And as we know, the stronger the foundations, the stronger the structure. So one of the ways I would suggest is how we can improve this without changing the structures of the governance is about listening to fans, about listening to volunteers and saying, okay, you are part and parcel of this pyramid, you are part and parcel of this model, what are your voices? And that's partly why the European model is so important, because it's part of civil society. Volunteering has been shown that it actually engages us democratically. It's part of democracy. It's part of us engaging with our communities. It's part of us meeting people who might be different. Kenneth said about there's competition, but there's also cooperation. Football is a strange ritual. Is that it brings people together, but equally divides them. Sometimes it divides us on nation states. Sometimes politics do kick in, and it's based on race or gender where we get divided. But equally, even if we hate the team opposite, we're still sharing that same ritual. We're still doing the same sport, the same activity. Across Europe on a 3 o'clock on a Saturday or 4 o'clock on a Sunday, millions of people are doing exactly the same thing, either watching or playing football. And it's that bit that we have to recognize is the bit that brings people together. And those people that make that are the fans and the volunteers who we should be bringing into those structures to say, right, what's your voice? What's your opinions?
Thank you. Ian, I want to talk about the court as an institution and how exposed it is to public opinion, to political atmospheres. So maybe in the Bosman case, I mean, I wasn't really around, but I can imagine that it was not something that before the judgment happened, your average football fan was speaking about in the pub or willing to go and pick it outside their stadium for. But we saw that with the reaction with the Super League, that this is very much in the consciousness of sports journalists, of football fans, of politicians. What does that do to the court, and how immune is the court from all of these political, this public opinion?
The court reads the newspapers. Luxembourg is a country which is in some ways a kind of fairy tale country in the mountains. The judges live a somewhat cloistered life. We're protected and well looked after and so on. So a bit isolated, and it's better that the court is in Luxembourg than if it were situated, say, in Brussels, the Washington of Europe. It is accustomed to being unpopular, and it's accustomed to disagreeing with one or several member states. Sometimes there are member states on one side and on the other side. So the court isn't surprised when member states express strong opinions. That said, the court does sometimes go in the wrong direction and then correct itself. Not often, but it does happen. And that happens in competition law, happens in other sectors that the court addresses. So it's not the case that the court produces a judgment to please the Daily Express or L'Equipe or La Stampa. That said, the court produces unanimous judgments. And if the judge is in the panel, then the judge, even if in the minority, will sign. But in the process of negotiating what the judgment will consist of, the judge in the minority will often say, okay, I can go along with it, but please, there is a concern. Would you give me this paragraph? And that paragraph gets inserted. And the challenge for court watchers is to read the entirety of the judgment in a balanced manner. Now, that's another way of saying sometimes the answers the court gives are not clear. And it may take, there are no dissents. And there's an American judge that said that a dissent is an appeal to the brooding future spirit of the law. And so these judgments which are difficult, which acknowledge two different points of view, are in a sense saying, that's as good as we can do for today, and we'll judge the next case when it comes.
One of the criticisms of the court, and you may already hear that I have a British accent, and the ECJ is...
That's all right.
It's okay.
That's all right.
This is a safe space
We're
for
one
us.
of the few native Anglophones here.
One of the criticisms of the ECJ, which has become a bogey institution for some Eurosceptics, is that it has a teleological element. So when it comes to actually protecting or promoting something European, or the specialness of something that is European, and as I already said, if the alternative looks American or Anglo-Saxonish, that the court will have this kind of inbuilt cultural bias to uphold that special Europeanness. Does Rantos, did that give a kind of taste, given how bold the judgment was, that actually this is the way the court may end up leaning? And does that do anything for the credibility of the court?
Okay, that's easy. The court is there to interpret the treaty, and from time to time the court has to make decisions which the drafters of the treaty couldn't reach political consensus on. For example, when a member state promises to reduce customs duty but doesn't, and the importer says, hey, you're breaking the Treaty of Rome, that's not appropriate, and the member state says, well, you can't invoke that principle, it's for the member states, it's an instruction to the country, it doesn't give you any access. Now, in a very celebrated judgment now, 50-something years old, the court said that the treaty creates rights for individuals, and therefore certain provisions of the treaty have direct effect. Now, the member states could not reach agreement on that, but it was the court who took the decision. Similarly, about equal pay for men and women, the treaty was not so clear about what the status was of that provision. So to say that the court has a teleological mission, yes, in a sense it does, because it's there to make sense of the not always perfectly clear European treaties. But it's not composed of raging nutters like Captain Queeg in the Caine Mutiny, who steers towards catastrophe. It's composed of people who are professionally rather conservative, intellectually curious, with really good legal staff who stop them from doing stupid things, and I speak from experience. But when a controversy comes, the court has to decide one way or another. And in the case of Bosman, the court decided to disregard, if that's the word, the strong representations of the member states. And since then, there's been a rolling back and a repeat. The constitutionalization of the status of sport, even though it's not perfectly clear in Article 165, that's a very powerful element for any judge in the court to say, this isn't just UEFA making it up. This isn't Benoit Keane being eloquent. This is something which has a constitutional root to it. And I think that should be the solution to the difficulties the court experiences.
Kenneth, I want to talk more, you're an economist, I want to talk more about maybe the specific financial benefits and drawbacks of having the system we have now. I mean, it's very commonly known that I think in the English Championship, if you get promoted, it's the most lucrative game in world football, given the windfalls you can generate by being in the Premier League. What is the level of financial volatility that comes with having a pyramid system where clubs' performance their performance results in their financial success or otherwise?
I think the biggest financial volatility is overspending. And you have seen that when a crisis like COVID-19 comes around. Look at FC Barcelona. I think you mentioned FC Barcelona and the huge debt level. That's just one example of clubs being up here in terms of revenue generation, but still getting in problems. And I think the big issue here is, and I emphasize that we have seen a lot of growth in football in terms of revenues over time, but we still see clubs overspend because there is the winner takes it all principle. So at the end of the season, there's only one winner, but you may have more teams spending to win. So players, agents taking too much money out of the system. So there's a fine balance here, but it also comes down, for me at least, to the question, is this about the sport of sport or the business of sport? So why are we passionate about football? It's not because of the business of football, it's because of the sport of football. If you take the North American sports economic model, it's very different. It's very centralized. The NFL, yeah, it's a great business. They have a TV deal which is much bigger than the Premier League. But then you had the case of Colin Kaepernick, one of their own heroes. So he was not good for the single entity of the business of the NFL, so they excluded him. And that's what may happen when, you know, sport is a business and sport is not a sport. So again, coming back to the solidarity, I think everyone can participate in European sports. But it's not only about spending money, it's also about spending money wisely. Manchester United is another example. They are not doing as well as they did under Ferguson. United's best season is in 1999, and it was a season when Manchester United won the treble based on the class of '92. So a class of players that came up through the academy. You can say the same for Guardiola's Barcelona team. Xavi, Iniesta, and the likes of those players coming up through La Masia. So if you can produce your product with that quality, but do it with the right economic efficiency and also the right organic growth and cohesion, then you can win big titles, and you can also get in a situation where it's good for your business.
Mark, we've spent a lot of time, you come in on that point, and also just I want to add, we spent a lot of time talking about the highest level clubs, the elite clubs, the ones who want to join the Super League. Maybe you could give us a sense of what it is at amateur levels, non-league levels, actually the bottom of the pyramid, and are they satisfied with how the system works for them?
Yeah, that's a really good question, because I think that Joel said about solidarity is the fundamental principle, and I think that's something that was jettisoned by the Premier League in '92. The whole premise of the Premier League was that they wanted to keep the revenues that they generated from television for themselves, with very small parachute payments coming down, which doesn't really filter through into the local FAs and into the non-league. But then coming back to your early point about volatility as well, is yes, there is a volatility, but that's equally about management as more than the volatility of the competition. But one thing we should say about volatility is that these organisations that we call football clubs have been in existence for over a century. Some formed in the 19th century, some in the early 20th century, and they're still going. And they're still going often with the same badge, the same colours, the same sort of even shared values in some cases. So how can we look at that longevity? Because if there's all this volatility, how many clubs actually go out of business? Now, one of the reasons that's the case is some of them are incredibly badly run. I was talking to Matteo earlier about, like in Italy, we've had clubs like Napoli, Fiorentina, Parma go bankrupt and come up through the leagues. But often what is the case is that the fans, the local people or the people who love the club are the ones who step in and keep that club alive and keep it going. So owners may come and go and players may come and go, but actually the people that tend to be there for a lot longer are those people who volunteer at the club or who are the fans. Now, at the lower leagues, I would say that's absolutely the case. The club I support is in the 8th tier of English football. None of you will have heard of it, but Whitehawk, I'm going to give them a shout out. But there's Nigel, John, Keith, who've basically been volunteering there for 40 years. They do the grounds, they put on the fixtures. Yeah, they're the lifeblood of the club. We even the fans will come and go. But those are the guys that really keep it going. But of course, that's their time, their dedication, and that's what so many clubs across Europe will be doing, which isn't the case when we look at, say, an American model, because the equivalent for the American model is the college teams, which are the feeder teams into the NFL, which are effectively run by universities. So it's a very different situation. So you don't have that civil society bringing people together. But in terms of the trickle down doesn't make it down there now.
You mentioned feeder clubs. This is not a widespread phenomenon, but we've seen richer clubs in Europe, I'm thinking of Man City in particular, whose owners want to set up a system where they have feeder clubs. So they will have relationships or even sometimes full ownership of smaller clubs in different parts of Europe who they loan out their talent to, or who they create a system whereby they take the players after they reach a certain age. You have Salzburg and Leipzig who have a similar kind of relationship given their ownership structure. Is this actually just ways of eroding the pyramid by the back door?
Oh, absolutely. Ian mentioned about the spectre of competition law. This is the paradox of competition law here, is that to make it more competitive, to let owners own clubs in this way actually allows them to monopolize. It actually allows them to buy up clubs in different states in order to effectively maintain their brand in one particular country, usually the Premier League, in order to reap the financial benefits of that. So it's actually anti-competitive, ironically. And I think that's the part of the problem. So, but then equally, the other head of the problem is we've now got nation states purchasing clubs in the UK and Paris. So that also tips the balance in a totally different direction, which again becomes anti-competitive in my view, because unless you've got an owner who is a billionaire, can you possibly compete?
And even a billionaire like Jim Radcliffe can't compete against the state.
Yeah, absolutely. Yes. So soon it's going to be a small number of nation states who'll be able to purchase clubs.
Do you have anything to say about the feeder club phenomenon? Is this something that you've looked at? I know it's still a niche pursuit, but we hear more and more of it when owners want to take over clubs, that they want feeder clubs.
Yeah, just quickly, I think it's another way also, for some clubs to work around the rules, especially if they have portfolio models with clubs outside the European Union. When you set up rules and regulations, these clubs that are in to win, they also become very creative. We have seen some examples of that, and now for me it's exciting, and we talked about it, Ian, at lunch, what will happen with Man City, because now they can't go to CAS to appeal.
Ian, do you want to come in on this point? Is there a legal aspect that you think could be brought under anti-competitive case against this system of buying up smaller clubs and using them for your talent production?
Well, one of the big controversies in competition law at the moment, where Europe and America are approaching it in slightly different ways, is the control over giants. And there are two big principles of competition law pretty much everywhere. One is prohibiting anti-competitive agreements, and the other is restraining monopoly or quasi-monopoly power. And on one side of the Atlantic, it's should Amazon and Google and Meta be subject to constraints because of what they are, just as much as because of what they do. Now, I would have thought that arguing that football clubs are in a dominant position, that's good try, but at first blush, I'd be a bit skeptical. I'd maybe add just one thing more generally. We've been talking at the moment only about football. Now, football seems to me a particularly good candidate for the European sports model. And I would say it's a better candidate than, for example, disciplines where the contests, the individual contests, can be arranged in very different formats. So cycling, skating, equestrian, horse jumping, you can imagine lots of different styles of organizing these events. And I can imagine more situations where the European or national organizer says, no, we're not going to allow that. That prohibition might seem arbitrary, could be maybe challenged because they would be exercising arbitrary, unreasonable hostility to 10-minute or 10-hour cycling contests. By contrast, in football, it's got to be a game of so many minutes. It's got to have 11 players on each side. The variability is limited, and therefore I'd have thought that the argument, this is the only way that it can be done, is more convincing in football than, for example, in other sporting disciplines.
You mentioned, just going back to football again, you mentioned that it's difficult to argue that clubs have monopolistic power, but isn't UEFA just a de facto monopoly of football in Europe?
It's a monopoly in the same way as Swiss railways are a monopoly. That doesn't make it bad. It makes it, the state is a monopoly, and European competition law is kind of unique in the world in that it applies to the state. So the state isn't immune by saying, oh, we're the state, you can't touch us, which is the case in the United States, the individual states. So I'm not so impressed by suggestions that the sporting federation in itself, because of its status, is unlawful. It has to be judged by the reasonableness, propriety, fairness, proportionality of what it does. But yes, it's held to it should be held to high standards of fairness, transparency, and all those good things.
The kind of riposte from the Super League advocates is that they will not have a closed system of just 10 or 12 clubs from Europe, but we've heard more recently that this could be expanded to 40 or 60 clubs, and it would actually be a tiered system of having leagues, 3 or 4 of them, and there could be internal competition between them, and that could coexist in a UEFA model. What do any of the panelists think about the sort of Super League 2.0?
Short answer, I don't believe in it. And I said it back in 2018 in a book chapter. Still stand there.
You don't believe in that it will happen, or you don't believe that it can coexist with...
I don't believe it will happen. So,
I mean, the spectre of the Super League has been here since the 1960s. It was first discussed then, and that's what I mean. It's the nature of football is a competition, and this is one of those competitions. It's going to constantly be used, utilising a sort of political similarities. Britain always used withdrawing from the EU as a stick to beat the EU with, and then they actually did it and then screwed themselves up. And potentially this is the same situation with the clubs, is that they'll use this as, and the Champions League reforms that will kick in next year, that power was, those clubs use that power to try to get more games, more television revenue, more opportunities to progress, to iron out the fluctuations, the volatility, so that they would guarantee getting through. The Champions League itself is already an opportunity, UEFA giving power to the clubs by saying, well, we'll give you a league structure and an opportunity therefore to get through. So that means that you can effectively, budget accordingly, buy the players, and are more likely to get through, so therefore you'll get more revenue at the end of it. And that's why we've got this dominant structure, and that pyramid's very top-heavy. But the Super League, and one of the challenges I always had when it was discussed in England was it was called the European Super League, and it's not. It's a Super League. They called it the Super League. The clubs at this point in time might be based in Europe. There's nothing to stop them playing games in as they do with the Spanish Super Cup playing in Saudi Arabia, or including, say, Brazilian teams into the Super League and making it a global league. And that ultimately potentially is where the challenge comes in, because that's where like FIFA might sort of go, oh, actually, this is our opportunity to get into club football. And then you create a very different model. But ultimately that, again, is undermined by the fact that I'll sort of challenge Ian a little bit on, I completely agree about you can put on a different cycling tournament in different ways. But football can be played in different ways. It can be played five-a-side, it can play futsal, beach football, etc., etc. And this is about the sustainability of football, which is if young people aren't playing 11-a-side football, does that mean that there's players who's going to be playing for these teams coming up through? Or are we assuming that the clubs are just going to be the academies and that the only people who play 11-a-side, because, for example, in American football, kids don't play in, they might play Little League Baseball, there might be people playing basketball in courts, but it doesn't, American football doesn't have that same sort of structure. And that might be the danger with football, is that we'll get more and more people playing 5-a-side, 7-a-side with their friends, playing futsal, but they're not going to be playing 11-a-side, which then threatens the very sustainability of all the other teams that aren't in the Super League, because there's just no players playing those sports.
Yeah, in the same book chapter that I was referring to, I talked about the Holy Trinity, and football is a religion here in Europe. And there is a coexistence between federations, leagues, clubs, and fans. I wrote here that they bear or lift common responsibilities to shape the quality of the overall product. So with that being said, why not try to create a bigger cake together instead of breaking out? That's still what I don't get. Also because these top clubs that wanted to be part of the European Super League, they have also gained a lot from playing in their domestic leagues, from being part of the European ecosystem. But I was pretty straightforward before when I said, I don't believe in the European Super League. I don't believe it will happen. And what we saw was that the German clubs was not part of it. The English clubs were soon to say, we break out as well. And you have a pretty strong club product in the Premier League. So if you don't get the German clubs and the English clubs to take part of this, that's another argument for it not going to be realized.
Does your kind of revolution in let's have a bigger pie and let's share it out require governments to get involved in regulation, or does it require UEFA to have a much stronger grip on creating certain types of culture across all of its leagues? Because there are huge disparities in the way different countries run their leagues and the powers various clubs have within their national countries.
That's why we need UEFA. And you saw also with the European Super League that the governments got involved. So with UEFA, with the national FAs, we have the backing of the national governments.
But is UEFA making the system less iniquitous? What is it doing right now to make your kind of vision of a more fairer system happen?
You have seen a Champions League where the sporting product has become better and better over the years. You have seen revenue generation go up. So it's a very, very strong product that they have now. They've had the same theme song for many years. They played at the same time, 2045 Central European time. I know they changed that, but they have an extremely strong brand. And the real strength of any sports brand is to be found in consumers, the people that consume and adopt the brand. So I think it speaks for itself.
The one thing I'd say about UEFA, though, is that it's part of the governance structure, and actually the European model of sport is about the primacy of national federations. And some of these issues are actually coming from within national leagues. So the Premier League they could do solidarity payments. That used to be the case with the Football League. They the Premier League decided that that's not what they wanted to do. So these things aren't necessarily coming from, UEFA could maybe change things, but ultimately the European model is about the primacy of national federations, which is also why it doesn't equally translate to an American model in the same way, simply because the states don't have the individual states don't regulate in a slightly different way. They all conform to the same similarity. Whereas it was mentioned earlier, how things operate in Luxembourg is very different from how it operates in England, which is very different from how it operates in Romania, and therefore it's very difficult then to consolidate all that.
Ian, I want to go back to this word solidarity, which I think is the most used and abused term in the EU's vernacular, and it's found in every sphere of EU life. In this particular area, does it have any legal weight, the idea of the European sports model promoting or encapsulating solidarity?
I think, personal view, it didn't have much substance in the early cases concerning sport and the merits of sporting organizations. And it had no traction at all that I could discern in for example, the Bosman case. On the other hand, the establishment of, or the insertion in the treaty of Article 165, it's about a page long, and it covers a bunch of propositions which no one could disagree with. I suppose solidarity is one of those words. I think it's the according of a special status to the specificities of sport, which is the most important ground for being hopeful that the outcome of this litigation will be positive for the sporting world. It's easy to say, this is so good for the environment. This is so good for avoiding domestic violence. This is so good for beating alcoholism. This is good for reducing pollution. This is good for so many things. And those arguments are made all the time, and they really don't carry people very far forward. One emotional element, which is maybe worth mentioning, in the argument in Bosman, the huge team representing UEFA, it had someone speaking French with a barbaric accent, wearing a wig and with a silk gown, very nice. But Mr. Bosman was there as hero and martyr. And he could say, I suffered because of the misapplication or the application of these rules. In the case of the European Super League, it's not solidarity, but solidarity, okay, I don't mind the word. It's the hundreds of stories that we've been hearing from individuals who devote their time to making football work. And the notion of the grassroots player who comes from a little town, who does well, who finds a club, who gets developed, who becomes a young star. I have in my family a spectacular athlete, a rugby player, who's become famous now, and he's now playing for a French club. Now, that's an extraordinary, charming story, and that is, for me, more compelling than we can make more money this way. And slogans like solidarity, yeah, okay, grassroots, okay, I'm not opposed to them. But I think it's the aggregation of personal testimonies which will maybe push the court in the right direction.
I'm not going to ask you what the right direction is, but we'll let everyone guess. I think we've come up to the hour, so now it's Christoph's job to curate the questions.
Yes, thank you very much for your debates. It was really interesting. We had some questions on the WhatsApp feed, so don't hesitate to ask questions via and through WhatsApp. I have selected 3 of them, one for each of you, but maybe it's my selection, so feel free to interact. The first question is coming from Romain Poirot, who is a scout in professional football, and it's for you, Marc. From a sociological point of view, what would football be like in the world of the European Super League? And more precisely, what is the current fans' point of view regarding the updating project presented 2 weeks ago by A22?
By A20?
The company who is managing the Super League, I guess.
Yeah. I think, it's very hard. It's very interesting when Ian talks about the stories, the aggregated stories of individuals sort of telling those emotional stories. I think that's one of the failures of the Super League, is that they haven't actually really told us very much. I mean, the whole thing was a debacle from start to finish. And I think that's one of the issues, is they haven't actually outlined how this is. They just assume that they can be part of the existing structures, drawing on all that solidarity, there's that word again, all those volunteers, all that talent, and then just go over here and play some games and make some money. They haven't then thought about, okay, what structures? Jean-François mentioned about the American structure where they just draw on the college system. So American football can say do that, whereas the Super League clubs won't be able to do that. And I'm guessing there won't be much solidarity afterwards if they do move, where clubs are going to go, yeah, you can just take our players. Now, there might be European law that says, well, you can't stop them, but then we might have a very different situation there. So I think from that point of view, they would have to be much more structured. And maybe we are seeing what you said, Maureen, about like these feeder clubs and a whole network of clubs, and they're going to have to be more professional in that way, and they're going to have to be much more structured. But then again, that would really, this is why I think this topic is really important, and it's important to discuss now, because it does get to the very roots of what the European sports model is. It's getting to the point where they might start, buying up other clubs to then basically feed into these clubs, which will undermine and just draw on all that talent and all that volunteerism, and undermine that solidarity. And I can't remember what the second part of the question was.
The second part was the spirit and the position of fans regarding the updating project of A22.
Well, there's been what was really interesting, as Maureen said, is about the visceral reaction, particularly in the UK. I'm also a committee member for Football Supporters Europe, and we organised a campaign, and again, pretty much called Win It on the Pitch. The idea that the football pyramid was that any club could work its way up and eventually win. Reality is not, you're not going to win it without a billionaire owner. But again, the fans, that there's mobilisation. And I think that's, again, one of the really interesting things about this, is that you wouldn't get these same sort of mobilizations from American football fans when someone moves the franchise from one city to another city. Whereas you do get that because of the emotional bonds, the visceral reaction. So the fact that fans are still mobilizing, the fact that they are still thinking about how do we stop this, and it might vary by country. It doesn't feel that way in Spain. The fans of Real Madrid and Barcelona don't seem as passionate about this. But, Kenneth's mentioned about, I don't think this will fly in Germany, definitely won't fly in Britain. So the fact that the fans are still mobilising tells us what is valuable about this particular model and why I think it should be kept.
Thank you very much. The second question was for you, Mr. Forrester Casey. Should sports federation have the right to take into account social objectives? Because we think that this was a point made in Bosman judgment. So what was the logic behind this?
Well, certainly federations are and should be entitled to bear in mind soft considerations which are relevant for the sport. I said that it was explained that dozens of top clubs in the top 2 leagues lost money on the basis of tickets and other revenue earners, but they were profitable because they were able to sell their players to famous clubs. That was just ignored. I think that federations maybe have realized that it's necessary to take account of of European law. They're certainly more aware of it than they were 25 years ago. And it's for federations to talk to governments in a way which takes account of the problems. It's easy, and it's easy in this room. I suspect that no one here disapproves of the European sporting model. I suspect everyone here hopes that the court will go the same way as Advocate General Rantos. Dissent is valuable, and seeking to hear and take account of an alternative point of view is essential, because all old grey-haired lawyers, of whom I have one, I'm wearing a tie to prove it, say a good settlement is better than a successful litigation.
Yes, for sure. Sorry, it was a question coming from Margot Basterex, a PhD student at the University of Limoges. I didn't precise it. And the last question is my question, in fact. That's my privilege. But it's for you, Kenneth. Do you think, sorry, that the promoters of the Super League are the most well-placed clubs to push some arguments? For example, they said that UEFA and sports institutions in general just want to protect their own interest or their monopoly, as we discussed. Should we believe them about that? And especially while FC Barcelona or Juventus are currently facing huge criminal proceedings regarding transfer fraud and referees corruption. So should we trust them when they say that they are going to improve the system and to be the white person that are going to improve the system?
So what's at stake here? It's about selling. It's about getting something. It's a legal war zone. So they do everything they can to win. So you will get a lot of arguments, and they are attacking, like I said in the beginning, a centerpiece of European culture, which still, from my point of view, will be a difficult battle for them to win. So I believe that we will hear a lot of things that we need to take with some consideration.
Okay. Thank you very much. Thank you. That's time for coffee break, and then we will have the second part of the conference.
Thank you for good moderation. I was just challenged.
Okay, let's start again for this second part of the conference. There will be a second panel in just a couple of minutes, but before that, as we presented part of our studies, we thought it was really interesting and important to have the presentation of a study conducted by the European Commission about the European sport model. So I will welcome Matteo Zacchetti on stage to present this study. Thank you to be here, and maybe you can just sit here to maybe this one. So you have the floor to present the main insights of this piece of work. And once again, I think it's, it's available publicly on your website.
Yes. Good morning, good afternoon, everybody, and thank you for the invitation. The study is this one, and it can be downloaded online. I sent the link, because apparently it's not easy to find it, so I sent the link to the number for the questions, but it's an SMS. I don't use WhatsApp, sorry. So, yes, my name is Matteo Zacchetti. I work for the European Commission, for the sport unit of the European Commission. We are part of the Directorate General Education and Culture. And just to give you a brief outline on what we do is basically, of course, our competencies have grown. Actually, I would say have started in 2007 with the Article 165 of the Lisbon Treaty. We mainly focus on communication, initiative and events in order to improve the participation rate of European citizens in sport and physical activity. You know that unfortunately the participation rate is still not satisfactory. For example, we have the European Week of Sport, we have the Healthy Lifestyle for All initiatives. Then we have, a financial support program for European projects. It's Erasmus Plus for sport. And by the way, when Mark was talking about the 1,000 ways that football can be played through a project financed by Erasmus Plus, we helped in the developing of another way of playing football, which is walking football. And that was a project, I think, of the Irish FA, together with the European Football Development Network. And I think it's an amazing project because it really literally lifted from the couch so many people. And the third pillar of our activities is policy and stakeholder dialogue. We organize every year the European Sport Forum, and we have a constant dialogue with sport stakeholders. We have arrangement for cooperations with UEFA and the European Olympic Committees, but we have a constant dialogue with all stakeholders. And we believe that this constant dialogue is part of the features of a European sport model, the involvement of all stakeholders, and of course those stakeholders that have a real representativity. So last year, actually in 2021, in summer 2021, we launched this study. Consultant Economists and Kia, Cairn European Affairs, were in charge of it. And it was, they worked on it at the same time while the Council was producing a resolution on the European sport model. So I think it has been important because, as it has mentioned by many of you, the origins of the European sport model go back to the past. It had already been mentioned in different official documents of the European Union, like the white paper on sport mentioned by Nathalie. Actually, I think, probably we as Commission, we owe to the Council the first mention of this sport model, and actually, a list of features that was made in 2000, in the year 2000, the European Council in Nice under French presidency. And it's quite interesting to read them out because actually I think it's even more complete of the kind of model we have developed with the study. So, of course, they mentioned the pyramid structure for the organization of sport and sport competitions with a central role for federations, a system of open competition with promotion and relegations, a broadly autonomous sport movement that may develop partnerships with public authorities, solidarity between the various constituent elements and operators, structures based on voluntary activity, and then something that, for example, hasn't been touched, but again, the importance of national teams and competitions between those teams. I mean, we've been talking about the closed league, the NBA, for example, and we know the issues that they create to national teams. I mean, how many times we were not able to see the best basketball players at the Olympics. And actually, some of those problems are happening now in Europe with the EuroLeague. And then, well, the involvement of public sector in financing sport, a focus on health, fight against doping, integrity, and the common management of amateur and professional sport, which again is part of keeping everybody together under the same umbrella. So this was basically the objective that we had with this study, is to take a snapshot of how sport is organized in Europe. We know there are differences. There are differences that are, you know, due to culture of a specific country or between sports. It's not the same football or archery. But still, I think our consultants were able to identify those commonalities that can be seen in the organization of mostly all sports. We mentioned the pyramid model. The sport federation are the main governing body. This is especially true for team sports. It's true also that leagues have a role in organizing competitions. Also, in certain sports, they have a role in negotiating audiovisual rights. Yes, especially in team sport, they have a role in the commercialization of their leagues. Yeah, we have the system of open competition, which is generally applied across European sport and universally followed in team sports. There are few exceptions, we know, in Europe. One of them is the basketball EuroLeague, but we have also the Six Nations. And I always wonder why Italy is always at the bottom and they still play year after year. But we say that this is the main, one of the main differences with the American organization of sport. Of course, is true. When talking about NBA, NFL, I think, I don't remember if somebody touched another issue that for me, as football fan, would be a huge problem. The fact of the trading of licenses. I always wondered why the Los Angeles Lakers are called the Lakers when Los Angeles is by the ocean. And actually because it was a team from Minnesota. So you can imagine that's tomorrow just talking about my team, Sampdoria, which is in deep financial trouble. Come somebody and transfer it to I don't know, to Sicily or even Dublin or anywhere else. And that could happen with the model, the American model of sport. I said Dublin because I remember that, not because I have anything against Dublin, but because I remember that at some point when one of the many projects of the European Super League was presented, they were talking about having big teams in Luxembourg, Dublin, Stockholm that could compete. So this is why I came to that. Also, I remember that at some point Wimbledon wanted to play matches in Dublin. So nothing against Dublin. So Well, what we said, it's valid, of course, for team sport. In individual sport, usually you have a ranking system. Different systems are applied. But again, there are mechanisms to guarantee fair and open competition. Financial solidarity, it's another extremely important feature. Those mechanisms need to remain a pillar of the European sport model in the future, need to be reinforced. And the redistribution of the resources generated by the elite has to go to help and support the grassroots level, the amateur level, the talent creation. And also the solidarity is between different levels of the same sport, but also among different sports. For example, the International Olympic Committee, the European Olympic Committee, and the national Olympic committees have these systems of redistributions. You already talked about the redistribution of the profits generated by the European competitions. So this is crucial. But, I mean, for many sports, is also still crucial the intervention of public authorities. And this brings us back to what, again, was already said as sport as a public, as a common good, as a collective good. Yeah, another feature is the autonomy. That is something that has also been recognized, I think, by in a declaration of a committee at the United Nations. But autonomy, sport has to be autonomous. Of course, this autonomy does not come for free. There are a set of conditions that have to be respected. The first is good governance. And good governance, of course, can be declined in many different ways. Well, good governance had not the same meaning 20 years ago, will not have the same meaning in 20 years. And this is a personal opinion, I think that today good governance means involvement of all stakeholders. And a real involvement, not just fake consultation, but being able to include them in the decision-making processes. And for example, I have to say that a few weeks ago, I think, UEFA signed a memorandum of cooperation, an agreement of cooperation with an organization of fans, a European organization of fans. And that, for me, it's crucial because fans, you know, have to be there. They are the backbone of the European sport model, and they are not enough represented in the decision-making processes of the federation. And finally, we come to the role of volunteers. Again, you said that before, and the worrying thing is that I think there is a decline in the numbers and maybe also in the quality of volunteers. I mean, this is probably linked with our lifestyle. COVID had an influence, but this is becoming a huge problem. So also I think the fact that the European population, or at least in many countries in Europe, the population is getting older. I mean, that has a real impact on sport, because volunteers are those who run clubs, are those who help when sport events are organized, and I think something has to be done. For example, in the study, there are a list of examples of, in some countries, for example, in the Netherlands, they are looking at mechanisms of providing training to volunteers, because volunteers, they need to do more and more specialized work. It's not sufficient anymore to be there and you know, just help out. You really need to be competent. So they are looking at providing specific trainings. Also in Slovakia, they are trying to provide, a special regime of taxation, of no taxation to the benefits, the modest gains that volunteers can have when helping out for sport issues. I have to say also that maybe it's something that it's not totally related, but as from this year, the Erasmus Plus program will also have a new possibility, which is basically the same kind of actions for which Erasmus became famous, which is the possibility for students to study in another country. Well, we will have sport mobility for sport staff. It will be modest at the beginning, but it's going to grow. And I think in a way it could be also a sort of kick to raising, to the not professionalization, but to having a volunteer, to raise the quality of the work of volunteers, and also to give them a sort of reward to what they do. Part of the study is also about identifying trends which could become opportunities or threats. For example, there was, again, I was thinking about something that has been said before. Why there's this this project of the European Super League came out? Well, of course, it's because we said a number of clubs, they want to have a bigger piece of the cake, but I think partly is also due to the internationalization of the audience, because in a way, Real Madrid or Manchester United are not only, the teams of their fans, but are those teams, those matches that are watched worldwide, in Asia, in the Gulf countries. And clearly, for them, European football is a huge success story. I always say that I think for Europe, football is a bit like Hollywood for the US, because it's a very important economic phenomenon, but with social and cultural also implications. So the reason why, me as a football fan, I'm not interested in seeing Manchester United against Real Madrid 6 times a year. But probably some Asian or Gulf countries fans, they are. So this is one of the reasons that explains. So, and clearly this is a threat, while the internationalization of audience should be seen also as an opportunity, because it means making the cake bigger, as we said before, but has also these negative consequences. What else? I think, yes, we mentioned good governance. I think I would say all European federations in the last 10 years have improved their governance standard, but still there's need of more transparency in certain areas. There's a need for a better representation of athletes' interests. We mentioned the fans, and also gender balance in leading roles. And by the way, this will be one of the subjects of the next edition of the European Sport Forum. Sorry. So giving a mic in the hands of an Italian while speaks is not easy, because I cannot I feel I cannot fully express myself, but still. So, yeah, and then there's an important thing which goes a bit out the field of organized sport, but sporting habits have shifted in the last 20 years. And again, COVID gave a big push to that. So there's less participation in clubs, And there are more participation in sporting activity outside formal settings, in informal settings, yoga, Pilates, all those activities, gyms in the parks, etc., etc. So these activities fall a bit now outside the scope of the European sport model. And possibly there should be some thinking about how to bring them in and so on. Lastly, just a word on the case, because we are all there for that. Of course, I will not comment, and I'm not from the legal service, so they would kill me if I say something. But I think what I can say is that this case, of course, has a value for football, for UEFA, for football fans and football clubs, but has a value for sport, because and has a big values also for the Commission, because it's. I think it would be the first time that Article 165 would have an interpretation, and if the approach of Advocate General Rantos would be somehow kept, it would mean a sort of constitutionalization of the European sport model. It would open to a next commissioner or a next European politician interested in sport a lot of opportunities to get more into the sport dynamics. So very curious to see what will happen. And well, for the moment, I think that's all on my side. Thank you.
Thank you very much, Matteo. And once again, we will send the full study and the link to download it, but it's available on the website. I think every study that you conduct are free.
Yes, they are. I know that our websites are not very easy to navigate, but
sometimes
yeah.
a bit. Thank you very much, Matteo. Let's now welcome the participants of the second panel. After having discussing about the benefits of the European sports model, we are going to discuss about the legal parts and the legal framework behind this. So I will call once again our brilliant Marine to moderate this panel. And I will call also Franck Lati, professor of international law at University Paris-Nanterre, Mr. José Rivas, partner at Bird & Bird. Maybe just the last seat, finally, sorry. Sorry, Mr. Vanias Mokvina, associate professor at the University of Rijeka, Faculty of Law, Croatia, and Mr. José Manuel Araujo, lawyer and chair of the EU Commission at the European Olympic Committee. Welcome, thank you, and Marine, you have the floor.
Brilliant, thank you so much, Christophe. I'm going to start with another caveat that I am not a lawyer, if it wasn't obvious from the first session. So I'm very glad to have such a brilliant and I think very brainy panel. So I might, I think, hopefully ask the questions a little bit slower this time, and also get you guys to elaborate on various issues that maybe for someone who's a novice or not such an expert into the legal mechanisms of the sports model would be interested in. So I know the article is coming up will be a sort of focus, maybe an initial focus of this discussion, and I've got it written down here because I don't want to be the kind of journalist who doesn't know her treaty articles well enough. And I think maybe it's helpful, Frank, if we could set out what Article 156 says about the European sports model, if there's any reference to a pyramid, why it's been interpreted in the particular way that we've been discussing it already today, which is a pyramid. And also maybe, I think Ian mentioned it in the last panel, how did this article come about in the Treaty for the Functioning of the European Union? It's a relatively novel edition.
Okay. Thank you for this first question. Maybe I can read the provision of Article 165 of the Treaty on the Functioning of the European Union. Paragraph 1 And second line, the Union shall contribute to the promotion of European sporting issues while taking into account the specific nature of sport, its structures based on voluntary activity, and its social and educational function. So this provision was introduced in the treaty through the Treaty of Lisbon in 2009. And so before that time, there was no reference to sports in the European treaties. So it was the first time that the word sport was introduced in the treaty. But previously, of course, there were some cases before the European Court of Justice, Bosman case, not to say the least. And also the European Commission, for example, worked on sports, and there were some political declarations by governments in favor of the social aspects of sports. So this provision is the result of these political actions, I would say, of governments. I'm not sure that there is a direct link between the Bosman case, for example, and this provision. Historically, sorry, it's more about the putting into words the different political actions by the governments or by the European Commission on the European model of sports. And there was a study by the European Commission on the European sports model that was released some years before. So this provision, as you can hear, does not mention the European sports model and doesn't mention the football pyramid. So it's an interpretation, and this interpretation was made by the Advocate General in the Super League case, when it said that this provision is constitutionalizing, as Matteo said before, is constitutionalizing the European model of sports, which includes the football pyramid. So this is not in the text, but it's an interpretation. I'm quite convinced by this interpretation, but it's not the pure wording of the text.
If in the final judgment this language that the AG used is repeated, is that the first real moment of constitutionalization of the model and the pyramid? Are there any other precedents where it's been mentioned as a legal precedent by the court?
So far, the court has not paid much attention to this provision. There are some references in some cases in the Olympique Lyonnais, for example, but just paid the lip service, I would say. But there was no real construction on this provision. And what the court applied are the general rules of competition law, which allows some justification, but it did not especially refer to this provision. So maybe in the Super League case, if the court follows what the Advocate General said, maybe then it will have to be more specific about this provision in the treaty, which it has not really done so far.
Vanya, maybe I can go to you about what the significance of the judgment might be, and also whether the notion of specificity will be included. And actually, even if for those of us who don't know, what is the sort of underpinnings for what specificity with regards to sport has come to mean in an EU legal context?
Well, it's hard to say what would be the result of the case. I think we are all sitting here, we have friends that are online following this important event, and firstly I would like to congratulate the organizers for making this wonderful, wonderful event, so really well done. If I may say, maybe I shouldn't say that, but we should praise the European Super League and the A22 for initiate the procedure, because now we are all speaking about the European model of sport. We are all speaking about the football pyramid. They achieved the result of uniting people around some elementary values, the values of solidarity, the values of the European model of sport, of promoting fairness, openness. We have now the supporters whose voice is being heard. We have the clubs association. We all know about the ECA, but now we have also the Union of European Clubs as a new emerging association, a new stakeholder. Of course, we have FIFPro Europe. So all those stakeholders are part of the so-called pyramid. And I'm not praising UEFA, but I must say that UEFA is giving praise and it's giving a hand for future collaboration to the stakeholders. Unfortunately, we can't say and we can't see that in some other sports. We're speaking about the European model of sport, but it seems that we are speaking about the European football model of sport. And we know that we have a lot of sports. It's sad that in other sports, we don't have such an issue of potential solidarity or redistribution of revenues. There are some exceptions, but generally, it's sad what happened in basketball. It's my opinion that it's a sad story that happened over there. But in the end, I think this case will help the European model of sport in any way. Probably, it's hard to say that the court will follow 100% what Advocate General wrote in his opinion. But in any way, I think it's good that we are discussing that. It's good that I read that, I think 2 months ago, the FIBA Europe, they were discussing what's going on about the European model of sport, and they see an opportunity for making better governance in basketball. The problem of the last panel is that a lot of nice things have been already said, and what Matteo said before, good governance is the clue. And here, UEFA is doing a lot.
Maybe on the point about away from football, Jose Manuel, how closely are you watching what happens in this case? And do you think it could provide a constitutional protection for Olympic sports and has a direct spillover for the way that Olympic sports are done in Europe and the governance around Olympic sports? Or is it much more, you will have to interpret what this might mean for you? Or is it more, as I said, is it more direct influence on how you do your business?
Well, first of all, thanks for inviting me to be in this conference. Obviously, I'm representing here, I'm a lawyer, but mainly I'm representing European Olympic committees that are following this case very closely. In fact, this is not the case of football. This is the case for the whole sports, non-Olympic and Olympic. Obviously, we are dealing with the Olympic sports, but as you know, European Olympic committees will organize the 3rd European Games in Krakow, in Poland, and we will have many non-Olympic disciplines and sports. So basically, this is the moment where we can get confirmation of this recognition of the European dimension of sport. That's the correct wording in the treaty. European dimension of sport, you can interpret it a little bit different, but this is the moment where we see that football can bring, the issue is there. Superliga is something that all the people understand, but we want to have this decision in order to all European federations can be legitimate to continue their work in order to guarantee this solidarity system, to guarantee the work they are doing. Well, basically the idea is that if we do this, if we have this consecrated this pyramid system, this solidarity system, then we can see that all European federations, all national federations can continue their work. So that's why we are concerned at the level of the European Olympic Committees, because if the court goes in the same way of this Ranto's opinion, that will give us all sport in Europe the capacity to keep on working, using that important tool that is good governance in national federations and European federations, and we have to deal with this very carefully, because by the end, if we do not have this recognition, that could be a big confusion, because we have to understand that we should have some flexibility. When we talk about football, about UEFA, about Champions League, we see other team sports following the same ideal. Let's see EHF Champions League, the European Handball Federation. We can see other sports. They have different approaches, like gymnastics, judo. Judo has, the Grand Slams, these competitions. They are completely the calendars for the International Federation and the European Federation and the national federations is completely okay, completely settled. So this is important that IFJ feels that the work done is okay, and then the replica for the European sport and for the national sport in Europe is the same. So that's why we are following this very attentively, and for us it's very important that we can have this decision as soon as possible in order to give them this possibility.
Thank you. To the other Jose, is there a danger that if the judgment is as unequivocal as the opinion, that it could cement the status quo as we know it, and then, as Jose Manuel said, maybe sort of shut the door on alternatives or flexibilities in models, because effectively the court has said, this is the way we do things, this is the way we're going to do things, and that will deter innovation, different forms of creativity and formats of other types of sports?
Well, I don't think that the court is going to say that. And the reason is because the court has not been asked that. At the end of the day, and I'm going to take a different angle to what has been said up to now. I'm going to talk about the application of competition law in the field of sports, and in particular, because it's the case at hand, in football. As you can imagine, Articles 101, 102, 85, at the time 86, have been there for 60 years. So this is not the first time that competition law applies to sport. And if it is not the first time that competition law applies to a sport, to the governing, to the running of a sport, the court must have said something about this already. And I think it has. Matteo stole the thunder with the white paper of 2007. Already the commission there analyzed the case law. But we have had competition law cases in the field of sport, Motoe, we have had Meca Medina. There have been many pronouncements of the courts. What does this mean? What does it mean, the application of competition law in this area? Well, at the end of the day, what it means, and what the court is likely to confirm following the opinion of Rantos, is that there are certain restrictions in order to organize a sport, and in order to organize a sport in Europe is following the European model, that are not caught by Articles 101 and 102. And this is the big surprise. But this has already been said. The pyramidal structure, I checked the case law. Advocate General Cocotte in Motoe already talks about the pyramidal structure. Rantos obviously makes a summary of what does that mean. And what it means is that provided the rules pursue a legitimate objective. Here is a difficult question. What is a legitimate objective? How many legitimate objectives do we have? What is part and parcel of the legitimate objectives of a sport? Well, that will depend to start with each individual sport. Provided they pursue that legitimate objective and provided they do it in a proportionate manner. Proportionate means in the legal world the least restrictive means to achieve that result. Those situations are not caught by Article 101 and 102. So this is what, if the court follows the Advocate General, is going to decide. And one fundamental question, one of those objectives that needs to be decided, is it a legitimate objective to admit who? Well, to admit someone that undermines the objectives of the sport, as I understand it, would be nonsense. Therefore, a sport federation confronted with a situation that somebody wants to enter, participate, if doesn't want to participate, is free to remain outside. But if wants to participate, will have to respect the rules of the game. And provided those rules pursue a legitimate objective and are proportionate, there is nothing wrong with it. This is what ultimately means to me, from a competition law point of view, the pyramidal structure, the specificities of a sport from the point of view of competition law.
So do you think, speaking about the constitutionality or the constitutional moment that it could be, is actually just overhyping almost what could happen in a couple of months, and it's better, as you said, to actually stick to what the court's been asked and what answer they will give? And as Ian mentioned, it might be very caveated and very long to read and full of other types of dissent. Like, should we not put too much pressure on this moment, is what it could mean
well,
for the sportsmen?
The pressure is put because it is there, and because we are talking about football. I mean, and that is a fact. It is a fact of life. But yes, my view is that this is very sexy because the sport in which it is happening, it is very sexy, but I can find traces in the case law as it stands today to say, well, this is the legal framework of analysis. What is interesting is that very little has been debated about the details. We're talking about, is the legal framework valid or not? To me, that decision had already been taken by the case law. What still remains to be decided is, are all the rules of the governing bodies of the sport correct? And the answer is no. In fact, the opinion of Advocate General Rantos in paragraph 121 already says there is one rule, and he says this is not proportionate. To prohibit or to impose sanctions on the football players is disproportionate. I was hoping that the debate that we would be having at European level now would be more this, rather than to go back and question the legal framework. To me, the legal framework was already there. There are valid grounds to maintain that the court has said what is that legal framework. The question is the individual application of that framework, where I think probably next year in this conference, I hope that that is what we will be debating. Is this rule in horse jumping? Is that rule in athletics? Is that is where the debate should be done. I am probably more optimistic than what you have heard up to now, but I think that yes, that European framework has already been recognized by the case law of the court.
Does anyone want to jump in? Yeah, Frank?
Yeah. Of course, I agree with you, but what is interesting is that in the opinion, there's a lot about Article 165, which according to was not necessary because there are already the general regime concerning legitimate objective, the proportionality test. So why so much time spent on this provision. And to my mind, it's because maybe under the general regime, maybe the case is not that sure. Maybe there is a risk. And I think that the Advocate General considered that it was time to insist on this provision, on Article 169, because it was a way to give more weight to the European sports model, to take it more into consideration because of this provision, which, and it says that the two articles on competition law should not be interpreted in isolation, but the European treaties must be interpreted as a whole, and there is this provision that gives weight to the European sports model. This is my interpretation.
Absolutely. I may have put too much weight on. Of course, it's an article that was introduced in the treaty, so it must mean something. And I think that that is what Rantos does. He encapsulates what is the constitutional dimension of that article. I'm not going to diminish the value of the article at all, no.
Vanya, do you want to come in on this? Or?
Well, just the constitutionalization of the Article 165 from the legal point of view, it's really a hard word. Maybe too strong. I think Advocate General was very, I think he made that on purpose. He wrote especially that, the constitutionalization of Article 165, and but the legal experts, the academics, when the opinion was made public, first they all jumped about that, constitutionalization of 165. We remember that we have a try about the constitutional treaty, but unfortunately it hasn't passed because the member states has been unable to make a decision, and then we had the Lisbon Treaty, and thanks to the Lisbon Treaty we have the 165 article. So from this point, I like the approach to be optimistic and try to put this article as a base of everything what you said. So I agree with my colleagues that the 165 is actually an article that is important to pass to the settled case law of the competition law, EU competition law.
I think people in my profession are also guilty of using hyperbole when it comes to some ECJ decisions, and every landmark decision is another step towards the constitutionalization of the treaty. I remember, I think maybe the case on Article 50 when it was heard at the ECJ and the member states lost was also considered to be one step closer to a federal or US way of thinking about what the treaty is. So yeah, maybe we should turn it down a little bit. In more, I think, parochial terms, Vanya, I want to talk about pre-authorization. What is it, and why is that the system that we have in place today?
Well, the pre-authorization is actually a rule set. We see in the opinion, but we know that in FIFA and UEFA regulations, you have a rule that gives the right to FIFA and UEFA to pre-authorize any competition. And those competitions are not just competition of clubs, competition between member states, or the association, and so on. And if we took this in the framework of the pyramid, of the concept of one federation per sport, it's obvious that we must have one federation that will settle the rules, and they did this. They settled the rules, and they said, okay, if you would play football in the organized football, like UEFA says, you must play according to the rules. And like Jose said, if you don't want to play on those rules, you're free to play somewhere else. But then, what will we have? I think that those clubs that have been commented today, some of them unfortunately face again some judicial problems. In that regard, I don't see a place for something like that, because they wanted a bigger pie than they already have, And today it was mentioned a few times that we have the G14 initiative going on for years, and this is a G14 in the, I don't know, 20th version, actually. It's called the European Super League. So, in the case, the Advocate General said the pre-authorization rules are something that is needed for the preservation of the system. And if you want to stay in the system, you should play according to the rules, as you said.
Jose Manuel, how does pre-authorization work in a specific example? Are you happy with that system? Does it give you a framework to protect the integrity of Olympic sports in Europe?
Yes, in fact. I'd just like to not forget that topic about the constitutionalization of the European model of sport. I would like to tell you that also for us it's important that later, after this case is finished, probably we have another environment to change Article 165 and then to get this confirmation of this perception. I don't know when we are going to do this, but that's a chance.
We'll need another conference on treaty change if it's going to happen, I think. I'm available.
In 20 years. But another thing that is important is what Jose Rivas mentioned about the athletes, about the football players that are going to be sanctioned by UEFA. This is what I was referring about the good governance principles in International Olympic Committee, EOC. What we say is that it is important that athletes participate more in the governing bodies of sport organizations. So if this opinion leads to a decision that refers that athletes should not be punished, for us it's important that that all governing bodies of the different sports can understand the participation of athletes in their decisions. That's one of the things that we are following attentively.
Jose Rivas, maybe come in on this point and I'll follow up.
Yes, authorization rules. Let me see whether I can give an example to try to understand the legal logic. And then we try to apply it to football. Imagine I am a federation for cycling. And the day of tomorrow, somebody comes and says, look, we are going to organize a race, and a new model of race, okay? And you know what? We are going to make our cyclists to ride without a helmet. And we want you to authorize our race, and we want you to authorize the cyclists that belong to your federation to participate in our race. Well, wearing a helmet, when I was a kid, cyclists didn't wear a helmet. That may shock many people in the audience, but that was, by the way, the first case on this issue is a Canadian case on ice hockey. The first time that the Canadian Ice Hockey Federation forced the athletes to wear protection and to wear a helmet. Well, if I am responsible for the sport, I will have something to say. I say, look, sorry, I cannot tolerate that somebody plays my sport, participates in my sport, putting their life at risk. And furthermore, I cannot tolerate that my members, this weekend, race with you without a helmet, next weekend, race with me with a helmet. How am I talking about grassroots, how am I going to explain this to a kid of 12, 13? How am I going to explain to the father of that kid, yeah, you can allow him to race tomorrow without a helmet, but next weekend he will have to wear a helmet. This is what cohesion, this is what rules, this is what governance of a sport means, and this is what we're talking about.
So the only way that those two things coexist is if you have a rival federation who has its own cyclists and they operate under their own terms and rules. Without any, like in boxing, we have various federations. They have, proliferation of federations in different types of sports. Okay, I understand that.
But if I may,
Sure.
but in boxing, unfortunately, we don't know who's the world champion. So I wouldn't like to have football like boxing. I think in football we know who is the champion, and that's the system. That's why we are saying the European football pyramid. That's it. I think in boxing, unfortunately, with all those federations, they didn't make a step forward. It's a real bad. It was really a bad step forward.
This is a question to anyone who wants to jump in, but is one of the reasons that the football model is being challenged is because the internal rules that UEFA have are under question about whether they are rigorous enough. So we have spending rules, FFP, Manchester City are back in the news not because of UEFA, because they've fallen foul of the Premier League rules, but there was a case Manchester City managed to, in most, I think, generous interpretation, get away with it. So a lot of these challenges seem to be coming up because the legitimacy of the almost self-governing nature of what football has become is under question because maybe people are losing faith in the rules themselves. Nobody wants to jump in. Go for it.
The self-governing nature of each sport is a reality. What each federation, what is the best for their sport. If you have a problem with some federation that does not apply any rule and is a mess, that's something that we should all focus on solving that situation. And we from Olympic Committee, obviously we are following this kind of situation. But when we talk about the capacity of each federation to organize its own competition, it's quite obvious for me. In fact, I was quoting some examples. Cycling is one example. You have some competitions in Europe, like the Tour de France, Vuelta, and we have athletes from different countries, from different teams, and this is UCI is dealing with this. The European Federation is also approving this. So each sport must be confident to organize as they want, and the rules must be adapted to the sport. So that's the most important, that this independence, this capacity of each national and European federation to organize its own sport.
Well, this is what I referred at the beginning, that I was hoping that we would be discussing this type of issues, individual implementation of the rules, individual application of the rules, because they may not be sufficiently clear, they may be discriminatory, they may not pursue a legitimate objective. All those questions, to me, are perfectly legitimate, and still that work remains to be done. But the debate today, it seems to me, to question the legal framework. This is what I meant by before. To me, the legal framework is relatively clear. The next step is going to be the concrete application of that legal framework. And there is where I believe there are lots of question marks.
Is that a debate that but is it actually happening in the national level? So, we have self-governance to some degree, but thinking about the UK, where maybe 2 weeks ago the government was going to put out a white paper sort of evaluating the self-governance of the Premier League football. It was delayed because of what happened in Manchester City, but there seems to be more political attention from governments about how their leagues operate and the rules within them. Is that the appropriate arena for this debate to happen, rather than at this sort of legal EU law level? Frank, do you want to?
Every country has its own specificities, and for the example, I know the best. You guess it's the French one. The situation of the national federation is quite specific because there is a kind of a delegation of public service by the states to the federation. So the application of competition law is quite limited, I would say, only to business activities of national federations. But the monopoly of national federation is protected by the law. So we don't really apply competition law to the sporting activities of the national federation, which is quite different at the European level, because there is no legal framework concerning all the sports organizations. So the way for the courts to control the activities of this organization is to go through competition law. And sometimes it's a bit weird, I would say, because if you took the example of anti-doping, this is the Mecca Medina case, the first instance tribunal, or the general court at that time, said that there is this kind exception concerning anti-doping rules, which should not be subject to competition law. There is this sporting exception. But the court ruled that, on the contrary, every sporting rule is supposed to comply with EU competition law. So my point is that it's quite different at the European level than at the national level. So I don't know what is the best system, but for me, having all the sporting activities under the lens of competition law is not the best solution, I would say. But it's the only way at the European level, or the freedom of movement of persons, capitals, and so on and so forth. But this is the only way for the European Court of Justice to control the activities of the sports organizations.
It's the only way under the current legal framework, I guess, if we speak about progressing the treaty or changing things, then, yeah, but that's a long way off.
Once I heard Advocate General Tesauro saying something like, what you are proposing is almost close to the Bible, to convert water into wine. Articles 101 and 102 are directly applicable. Have they been there? National courts have the competence to apply them. National competition authorities have the competence to apply them. That train is already gone. And we have to accept it. Yes, there are cases at national level.
Is there a danger of the kind of over-politicization of sport in Europe now? So we heard from Matteo, who said actually, you know, having the European sports model is great for the Commission. It's like good PR. We can tweet about, you know, the European values every time it's the Champions League final, etc., which they do. Jose Manuel, are you worried? Do you want European sports to be closely affiliated to EU institutions? And is there a danger that, you know, for example, UEFA is not an EU body, it does represent members that are outside the European Union. How do you kind of square this sort of circle? And would you rather that politicians stop speaking about your sports than sort of bigging you up?
Well, yeah, that's, well, basically what I feel from this about this subject is that, in fact, as you said, UEFA and European Olympic Committees represent much more than EU countries, and but we all at the level of EU must fulfill the legal framework of the European Union, and in fact there is a balance that is not easy for many of them. For most of the European federations, it's if we use EU as a standard, that can be very useful, because we could recognize that these steps were done much before others to think about it. So I'm not. I do not have a fear of the application of EU legislation to national federations in EU countries, and we don't have to fear that EU gives some signs to UEFA or to other European federations in order to fulfill some criteria. So this is not obviously that we have to tackle with these differences, but I'm not worried about or cautious about this situation. I think that in the future, this we will talk about the European model of sport, and we will talk about grassroots. And I feel that many, as I was saying, after this case finishes, probably we will have some capacity to have more intervention of European Union in some areas of sport. And I would say this, I'm not claiming, but Erasmus Plus is a program for to support many areas, also sport, a short percentage. I feel that for non-professional sport, we should have something from EU to support this area. We are talking about volunteer people. We are talking about the capacity to involve young youth in sport. So I think that probably if the result is a new approach from EU to sport, that could be good.
So one of the arguments made by the company that's now sort of representing the Super League is that they require the Super League to compete with the real Super League, which they say is the Premier League. So there will be no English clubs or no plans to have English clubs in this new Super League. Do any of you give credence to this argument that actually the iniquities of the way the wealth is distributed has meant that English football is raced to become the most lucrative, the most influential, where all the talent goes, and therefore, in response and to become more competitive, you need something that can have, I think, maybe the credibility and the clout to compete with English Premier League football, which has become a Super League. Does this have any legal weight or any, is it an argument which can be defended in any court?
Well, when we speak about the Premier League as a Super League, it's an argument that was also raised yesterday by Adriano Galliani, former AC Milan director, and now he is in head of Monza Calcio. It's a question, it deals with your previous question about national politics. We know that actually the issue about taxation is in hand of the national governments. So if you want to have your national competition be more competitive, you have some opportunities to do that. The Premier League is very much powerful. Yes, they have a lot of revenues. But let's be honest. In sports, in world sports, the global products are the UEFA competitions and are the competitions of the top 5 leagues in football. They are selling around. They make huge profits, and those are extreme powerful products. Today we spoke about the NFL, we spoke about the NBA, we spoke about the National Baseball, or I don't know, other federations. But people around the world watch European football, and that's it. This is the real European product that has a big value in the world. One other thing we didn't have the option to tackle yet, and very shortly, is the issue about the sport governing bodies having the regulatory power and economic power. And in the case, the European Super League is contesting that and saying, well, it's not fair, they have a monopoly situation, they should not have the right to commercialize their regulatory powers. But let's see what happened in tennis with the ITF and the Davis Cup. So they sign a contract with a privately owned company for a 10-year contract. They completely changed the system of the Davis Cup, and after just 1 year or 2 years, they said, well, it's not working. And the company, they said, well, we are not interested anymore. And they left. So, and that could happen in football. It could happen in other sports. The European Super League and the A22 are privately companies. I heard that they have the same address in Madrid, But nobody knows that. Nobody knows who is leading the companies. Nobody knows who is standing behind them. But when you have a sport governing bodies, you know who is the president, you know who is the member of the EXCO, you know. Everything is obvious. So, okay, there is place for better governance and with more involvement of the stakeholders, with maybe a better redistribution of revenues. It could be a better level, but to commercialize everything, I don't see it as a next step in Europe.
Yes, I think your question has to do with the dual role that you are referring to, no? The fact that the regulator also has an interest, an economic interest. Well, the Advocate General deals with the issue, but I would like to refer to two words that have been already mentioned. Matteo, you said autonomy in the regulation of the sport can come with conditions. Ian, you said that the federations should be held to a very high standard of European law. This responsibility comes with obligations. And this is not for free. And this is exactly what European law is saying. You have to be particularly careful because you are, some people talk about a situation of conflict of interest. Advocate General uses threat of conflict of interest. But because of that situation, they have to be particularly careful and they have to be exquisite in their way of regulation.
On this point, there was a recent appeal in Madrid, which the company A22 actually won against the ability of the existing body to sanction them. What is the significance of that kind of decision?
Well, the situation in Madrid is quite complicated because there have been several orders. In fact, you are referring to the last one. The last one lifts the interim measures that had been adopted, okay? And basically says, reimposes the interim measures. None of the federations, clubs, Liga, etc., can do anything to put at jeopardy the development of this new Super League. Okay. Now, a couple of observations. To my mind, it is surprising that that order, which happens 1.5 months after the opinion of Advocate General Rantos, does not mention the opinion at all, not once. Even to criticize and to say, look, I disagree for the following reasons. I don't share this point of view or that point of view. To me, that is telling. There is an argument to say in interim measures, you have to decide the situation at the time they were granted. Well, Advocate General opinion is not a decision, it's simply an opinion, and what the Advocate General does is summarize the case law as he understands it. So if I were sitting in that court, I would have said, let's see what he has said, even to disagree. Okay, so that is one point. I find that a little bit surprising. But what it is interesting is that obviously does not make any reference to the opinion of the Advocate General, Rantos, because there is no reference whatsoever of substance on what we are talking about, on this governance obligation of the federations. But that order is an appeal of a previous order. That order did mention this type of issue. So we are confronted in a situation where the previous order did what, in my opinion, is a proper analysis of the case law. These are the competences of sporting governing bodies, but the last order to which you are referring does not mention it at all and does not mention the opinion of the Advocate General. What it means, that was your question, is that the interim measures are back unenforceable, so therefore no measure can be adopted to prevent the development of the Super League.
Frank, I just want to go back to the previous point about maybe the tension between the governance role and the commercial role. Do you think that there is a tension, and does the huge amount of money that can go into certain game, in this case football, does it undermine the spirit of what the European sports model is supposed to be?
As a matter of fact, there's more and more money in sports, in football, and of course this has an impact. This has had an impact concerning especially the application of competition law. This is normal. More business, then more application of EU law and especially competition law. So nothing is surprising. The problem is that sometimes sports, and especially football, may resemble a pure profit-driven model. I think that's the problem. It's not the case, but it is often perceived as being a profit-driven model. And I think there is maybe what I would call an ethical issue. And maybe sports organizations should be more careful. Maybe they should not seize every business opportunity. Maybe there should be some self-restraint. I take one example that we had to deal before the ethics committee of the French Tennis Federation concerning a partnership, commercial partnership with an online betting operator. And as an ethics committee, we say that maybe it's not a good idea for the federation to have this partnership because it's a way to encourage online betting. And we all know the social consequences or the harassment on tennis players when they lose a game where there was some betting on the game. So we said maybe it's not the role of a federation to have such kind of partnership. And so I think it's more general issue. Do sports organizations have to seize every business opportunity? Maybe they should be more careful and maybe focus more on the regulation of the sports. And so this is what I think as an ethical point of view. On the other end, of course, in the construction of the sports specificities, it was mentioned earlier, there are some responsibilities concerning the good governance, concerning the role in social integration or the promotion of amateur sports. So I think these elements are very important, and they should be taken into consideration by sports organizations because this is a way of protecting the specificity of sports.
Jose Manuel, I'll come to you. Maybe you can speak on that point actually, and then I'll follow up.
I would like to say that for us it's really important that this opinion and this case finishes. After this case, probably we avoid the possibility of some company to pick some clubs and decide in any sport to organize something. But we cannot avoid, and we want to, that European federations, national federations can talk with private companies and say, we should improve this, we should have better commercial rights of this competition. We have capacity, you probably have more knowledge on this, so let's cooperate. This is one of the things that I mentioned some months ago in the Global Sports Week. It's important that private companies that are interested in sport and European federations, the national federations can talk and then can solve this, not having someone that comes from we don't know where to decide we are going to do something like a closed league, like in the States. So if this case finishes like we expect to do, that could be a very important moment for European federations, for national federations to get the idea of having more companies with them, more to find the way to promote their own sport. So I'm sure that that can be one step. Good governance will also will also says this. It's important that we can have all stakeholders. I mentioned the athletes before. We mentioned before the fans. In fact, it is important that the whole governing body of a sport can understand this capacity they have and this possibility they have to have other stakeholders, other companies, private companies interested in their sport.
Maybe just finally, because we've got a few minutes, I'll ask everyone if they can 1 minute intervention about going forward and whether you're optimistic that the pyramid can be preserved, strengthened and improved if the judgment goes as expected, or actually maybe there's a risk that some complacency will set in because, well, we won the case and the big existential threat to our model is gone, and therefore that might breed some degree of triumphalism and actually stop the reform effort. I'm looking at you.
Want me to go?
Yeah.
Well, I have to be optimistic with the pyramid. First, because with the pyramid to as a shorthand of what we are talking about, okay? Why? Because it is in the law as we speak. If there was any doubt, Article 165 has codified that it is in the law. So in the long run, I am optimistic. In the short run, I am pessimistic. Look at the order that you were referring to of the 30th of January of this year. No reference, no recognition, no nothing. So it is going to be a struggle.
I'm optimistic. But as I already said, I think, and Advocate General Arantos said that he see that the court will give, of course, the final opinion about, for example, the solidarity, the redistribution. Is it enough, or should be maybe more? I think the good governance principle I've mentioned a few times already. The involvement of the stakeholders, even some new stakeholders, and especially the supporters. And we don't have the supporters in the pyramid, so it's a pyramid with a sun. Let's put the supporters in like a sun in that picture. I think in the end the European model of sport will upgrade to the next level, and this case will help, I'm pretty much sure, all other sports, not just team sports, but as Jose also said, also individual sports, and that's important that the preservation of the European model of sport can continue.
It's difficult to read in a crystal ball. I don't know if I'm optimistic or pessimistic. I'm sure that the court will rule that there is this legitimate objective, the preservation of the football pyramid. Concerning the proportionality test, I'm not that sure it will succeed. I don't know. There are some arguments for and arguments against, and if we can follow the opinion of Rantos, and everything would be fine. Will it be the position of the court? I have no idea. If let's imagine that the court rules that the system is not working anymore, we have to change the treaty, which would be quite difficult. So I hope that Article 165 will be convincing enough for the court to preserve that system.
And finally, Jose Manuel.
Yeah, optimistic, definitely. Well, my feeling is that after this case, we will have this solidarity mechanism improving. And when we talk, no one talked about this, but UEFA distributes 85% of the revenues of their competitions to national federations, well, to their programs. 85 is good. International Olympic Committee distributes 90% of their revenues. It's a little bit better, but obviously the intention is that all European federations can distribute, can make more money and distribute to the base of the pyramid, to the grassroots clubs that should be helped because they are the base of sport in Europe. So I suppose for us, during COVID-19, our main concern was the clubs. In fact, we saw that the clubs decreased the number of athletes. We have other physical activities, gyms, getting more people. But in fact, the base of this whole world of sport in Europe is the club, the volunteer, those who are working with getting no money, but having the hope to have someone that goes from the beginning to the top. And they can say, as I can say in Portugal, when you say that a club in Madeira starts with Cristiano Ronaldo and by the end he comes to be the first in the world, they say he started here. It started with me. I was the coach that started this start. This is important, and this feedback is very important for all clubs that are at this level.
Brilliant, thank you. I'm going to hand over to Christoph now with some questions.
Yes, many questions on this panel. Unfortunately, we have problems of timekeeping, so I will just take two of them. They are not named, so maybe any one of you who want to answer is welcome. The first one is from Holger Preus, professor at University of Mainz. It's about solidarity. We have been talking a lot about solidarity today, including as a legitimate objective recognized by the European Court of Justice. And I think we all think that we need more solidarity in the current system. And the question was, how can we achieve, in fact, more solidarity? Should the largest leagues also contribute to the European solidarity efforts? And could we envisage a truly European solidarity model where everybody, UEFA, national federations and leagues, contributes to this solidarity? So I don't know, it's about this European solidarity effort. How can we achieve it, in fact? I don't know who wants to answer.
It's almost a question for Matteo, no? Rather than the panel.
I have already answered to this because, in fact, when we talk about the capacity of European federations to distribute their revenues, it's the most important, and we have to give signs to all governing bodies in Europe for all sports that they should invest in grassroots clubs and put the money got in the top of the pyramid in the bottom.
Yes, I think it was also regarding the legal tools that we can use about that in order to maybe implement a tax, such as in France we have the tax buffet, or to implement regulations such as salary caps or so on. So what tools can be used without, in fact, taking into account that the clubs should remain autonomous, because this has been discussed too. So what legal tools can be used? I don't know, Vanya, you didn't want to answer to that question, but
that's a difficult question with legal tools. But I just wanted to say, for example, in other sports, the issue is about the revenue distribution. We already heard today that UEFA is redistributing more than 90% of their revenue, so 3 billion euros are redistributed to the clubs. Not just those that are competing in the UEFA competition, but also other national clubs. So when a club plays in the Champions League of a small country like Croatia or Luxembourg, all other clubs that are competing in the first division will get some revenue. And for some smaller clubs, €500,000, 1 million euro, it's more than half of the budget. So that's something that helps a lot the academia. And those money should be spent for the development of youth, for the academia, and that's important. In other sports, and also UEFA is redistributing money to its member federations for some other project, Hat-Trick, or some other project where they build the infrastructure, help rebuilding the infrastructure for some, it maybe sounds bad, but in some poorer country that don't have the money to build, to invest in infrastructure, that project can help a lot. In basketball, for example, if you want to organize an event, you must ask your government to give you money to actually set a competition. You will not get any money from the FIBA Europe, unfortunately, and said the same story from the other sports. And that is the problem. Because of lack of revenue distribution in basketball, we had the case like we had because the federation were unable to, or they're unwilling to stop the clubs working on those breakout leagues.
Maybe a last topic about this question. In the case that we would have a public or private regulation trying to implement solidarity, would there be a threat that it could be considered as anti-competitive? I think that it's not a threat at all because, once again, in France we have the tax buffet, which is based on the TV rights, for example. So no threat at all. We can try to push in order to increase this solidarity. You think we have legal tools right now?
It's a difficult question. I think that it's in the power of the federation, the European Federation, that have the power to redistribute with their rules that money, like some other do. And then we will have some redistribution in other sports and development of other sports.
Okay, thank you very much. And you were talking about basketball. So the last question is coming from Emily Wisnowski, Legal Affairs Manager at FIBA. It's not fully about basketball, but maybe we'll discuss after the conference about what you just said. The question is, and once again, you can answer whoever wants to answer, is it true that a structural separation between regulatory and commercial functions of sports governing bodies is not required under EU law? We discussed a bit about that, but not very precisely. I don't know, Frank, maybe, or whoever you want.
I can give an answer from a competition law point of view, and the answer is no, it is not required. And it has happened in one sport, to the best of my knowledge, it is automotive, but it was a proposal by those subject to the investigation. But EU law does not, EU competition law does not impose such an obligation as such. And by the way, Rantos makes reference to that point, from competition law point of view.
Okay, I think that's perfectly answered to the question, so thank you very much. Thank you all for this panel and these debates. Thank you, Marine, also. So I invite you to join your seat, and that will be the final part of this conference. Just a couple of things before leaving the floor to the last speaker. Thank you very much to have been here and to have been asking many questions. Sorry not to have been able to ask all the questions. Once again, only 15 minutes would have not been enough. Also, for the people that are attending and following the event online, do not hesitate to contact us after, just to ask questions or to express something about the conference. We would be more than happy to answer you and to give you any insights or elements that you would need. So you have our contact details on our website, www.cdes.com.fr. So you can contact us, and we will be happy to answer if you have any question. So now I think it's time to finish and to conclude. I will call on stage José Luis da Cruz Vilassa. José Luis is a managing partner at Cruz Vilassa Advocados and also former judge of the Court of Justice of the European Union. So we have asked him to conclude and wrap up a bit the debates. So that's the floor is yours, and thank you very much.
Thank you very much, Christian. Okay, thank you. Well, now I feel more comfortable. Good afternoon, everyone. This is not really a comfortable position to be the last speaker at this conference. Everything has been... Oh, sorry. Is it working? Okay, thank you. Everything has already been said, so it remains. It doesn't remain very much to be said. I will also have to go back to some of the issues that have been debated and that have been at the center of some interventions in this conference. But before that, I very much would like to thank you for inviting me to come and for giving me the honor of closing this conference. And also congratulations for the impeccable organization. Also for this Luxembourgish weather, which reminded me of some other countries where I used to live, like Portugal, for instance. But having lived for 16 years in Luxembourg, this was exactly the winter weather that I liked to have when I was in Luxembourg. This was really my favorite time in Luxembourg, was when it was like this. Thank you very much for having also so well organized this detail of the organization. I must begin my remarks by disclosing two facts. Firstly, I have been, as has been said, a member of the Court of Justice of the European Union as Advocate General and as Judge for 16 years. But I am now, I am not anymore a member of the court, so I'm free and never had sitting in a case about football. Not in Bosman, was when Ian acted in the Bosman case. I was president of the court of first instance, not the general court, so we didn't cross at that time. But now I'm entirely free to express my opinions. Actually, I did it at the hearing because I had the privilege of representing the Portuguese Republic as a lawyer at the hearing before the Court of Justice on the 11th and 12th of July concerning exactly the European Super League. And I was impressed by the fact that 24 member states of the European Economic Area submitted written or oral observations, or both, to the court, which, of course, bears witness to the importance they attach to the issue at stake. And moreover, the views expressed by them, by all them, at least during the hearing. I could explain why I say at least during the hearing, but we have no time. Were unanimously in favor of the compatibility with EU law of the UEFA rules at issue, excepting one that has already been mentioned, in particular sanctions applied to players that were not involved in the project of setting up a rival league. Of course, I was acting on behalf of the Portuguese government, but the positions I expressed at the time, it happens that they coincide exactly with mine. So they may be considered as also my own positions. And it happens that I haven't changed my mind in the meantime. Second disclosure, as the great Spanish thinker of the 20th century, Ortega y Gasset, wrote, each person is him or herself and his circumstance. I was born in Braga, a town in the north of Portugal, and I do not exclude this may be part of my circumstance. I'm sure this is part of my circumstance. I have been, and I still am, a fan of Sporting Braga. And Sporting Braga, which is currently classified third in the Portuguese Championship, but was in the past oscillating between the first and the second Portuguese leagues, is now, year on year, a regular candidate to the main UEFA leagues. But I guess it would hardly been admitted to play, it would ever been hardly admitted to play in the European Super League. Different sports which are organized, this has been said so far, different sports which are organized at European level have chosen the structure and the working rules that they consider the most suitable in view of the characteristics of the sporting activity and which they consider more conform with their objectives and organizational preferences. My short talk will be about a topic, I'm sorry, I must come back to there, about what I would call a constitutional view of European football. Once again, we have to go back to the constitutionality or the constitutionalization of sport at the level of the treaties. I've written several articles on the constitutionalization of the treaties. This has nothing to do with the constitutionalizations of the treaties, but it's a small part of it. I actually am in this respect in the good and honorable company of Advocate General Rantos. In his opinion, it was the first time an official document of the Court of Justice written by an Advocate General spoke of the constitutional dimension of the sport, but allow me to remember that modestly this same idea was put forward by the representative of the Portuguese Republic during the hearing. What I'm going to do is mainly to try to draw some inferences and to give this concept a meaning, and to draw the inferences that it is possible to draw from it. It's not just a word, but it shall imply some changes. From the outset, because unlike in previous cases, even in Bosman, where specific rules applicable mainly to the relations between clubs and their players were questioned before the Court of Justice, the European Super League case touches the heart of the system of rules currently regulating inter-clubs competitions in Europe. I will now try to simplify at my own risk, thus avoiding to add complexity to what is already complex enough. And please do not expect me to predict the outcome of the case, even though the analytical tools that I normally use are well known to the court. But I will make no guess about that. We already know, I don't need to come to that. I could come very, very briefly and give you my own version of the main features of the what is known as the European sporting model. but it has been already declined in several tones during this conference. I will not go back to the pyramidal structure and what that means. The open system of open competitions. The pyramidal model is also means of making competition work at the European and world level. How could you do otherwise to have to organize and harmonize competitions? Solidarity and redistribution mechanism. And I will just insist in another point is the system of governance, which is a representative and professional system, which includes, and this in my view it's important, an impartial and independent internal dispute settlement mechanism under the control of national and EU courts in their respective jurisdictions when they come into play, which is the case now with the European Super League. Unless, of course, it is a matter of strictly sporting nature, essentially the so-called rules of the game. It is true, as has already been mentioned, that the European sporting model is not precisely defined in the treaty. But we know what are the values, and they are in some way in Articles 165. We know what are the values inherent in it, and the building blocks of such model are finally there. Fairness and openness in sporting competitions, cooperation between bodies responsible for sport, and the protection of the physical and moral integrity of sportsmen and sportswomen, especially the youngest. And moreover, as has been already highlighted, since football is a sport based on the interdependence of competitors, the maintenance of a certain competitive balance is essential in order to maintain the interest of spectators may have in the competition. But let me begin by setting the scene clearly. FIFA was founded in 1904. This is 119 years ago. And UEFA in 1954, around 69 years ago. And they were created on the initiative of civil society, more precisely by those directly interested in organizing at national and supranational level the practice of a sporting game that was becoming increasingly popular, particularly in the United Kingdom and in continental Europe. They were set up as private, non-profit associations of international scope with headquarters in Switzerland and governed by Swiss law. Clearly, an organization of this size and ambition could not do without rules and statutes able to ensure it operated in the best and most appropriate conditions. I'm not able to open my bottle. Thank you. It is, and in this context, I think very clearly that it is not up to anyone other than the institutions representing the federations and clubs to choose within their own ecosystem the type of organization of sporting activity that they prefer, in the light of their objectives and the specific characteristics of their activity. It was therefore in the exercise of the fundamental freedoms of assembly and association, now enshrined in Article 12 of the Charter of Fundamental Rights of the European Union, that UEFA and FIFA were created and continue to maintain operating rules capable of ensuring that a system of competitions can function at regional, UEFA, and world FIFA level. In case Pio some years ago, the legitimacy of FIFA to adopt its players' agents regulations was contested, based on the argument that such rules did not have a sport-related object, but regulated an economic activity that was peripheral to its sporting activity. The situation in this case, the ESL case, is totally different. And there is absolutely no reason to consider that the contested rules, in my view, are not directly connected with the organization of sport at European and global level, and would not fall within the scope of the freedom of internal organization enjoyed by sports associations like FIFA and UEFA, as was recognized by the Court of Justice. This does not mean, as the court has also made clear, both in Liège and in Letonen, that in the exercise of their organizational autonomy, these institutions are exempted from the mandatory rules adopted either by their respective states or by the European Union. The European sports model cannot be equated to a lawless territory. It's another way to say something that has already been said this afternoon. In any case, it's not like a sporting exception. When those rules and statutes concern the exercise of an economic activity, they may be caught by rules on competition and the rules on the internal market. But it's a normal relationship. They apply to economic activities, and it's only when they concern an economic activity that they may be caught by those rules. So far, I could say that there is nothing new under the sun. However, and now that's why that's on the central point of my talk. Something has changed after the Lisbon Treaty has introduced Article 165 in the Treaty of Functioning of the European Union. It has rightly been at the center of several interventions this afternoon. Then sport has been added to the list of subjects, education, vocational training, and youth, that were included in Article 149 of the Treaty on the European Communities. And I think it was my expression I used during the hearing, this elevated sport to the status of a subject with constitutional dignity. And in my view, as I said, this cannot fail to have important legal consequences for the application of the treaties. Such change did not happen by chance or from one moment to the next. It has already been recalled that it was the result of a process which has been announced and encouraged and promoted by the Union's political institutions, from the Amsterdam Declaration on Sport of 1997 or the Helsinki Report of 1999, to the Commission's White Paper of 2007, and upheld by the Court of Justice in several judgments. This process of constitutionalization of the phenomenon of the sport in the Union was intended to respond to the changes which, for better or for worse, had resulted from the actions of the actors of the mass social process linked to certain sports, in particular to football. The growing commercialization of sport, the violence sometimes associated with sporting passion, and the marginalization of certain social groups, particularly in times of economic and social crisis, have increased the concern of civil society, states, international organizations, and the EU. Transposed into the text of Article 165, the concerns arising therefrom express themselves in the reference to the specific nature of sport. In my view, the significance of this is twofold. First of all, the need to preserve the integrity of the European sporting model requires, in accordance with the horizontal logic of interpretation, that where an economic activity is carried out in relation to sport, Articles 101, 102, and internal market rules be read in conjunction, not only apply, but also be read in conjunction with Article 165. Secondly, any potential infringement of the competition rules by UEFA regulations can be considered as established only after a thorough analysis of its effects. Any qualification, this was discussed in the Advocate General Ranto's opinion, only after a thorough analysis of its effects, any qualification of a given practice as an infringement by object, an infringement per se, being excluded, in my view, in light of the constitutional recognition of the legitimacy of the objectives pursued by those regulations in the whole. This equation was particularly well elucidated in a judgment of some years ago, Wouters, in paragraph 97 of Wouters, for which I wrote the observations of the Portuguese Republic on behalf of the Portuguese bar, on the basis of which I really recommend you this paragraph 97, which finally gives the key for this equation, on the basis of which it is possible to conclude, and only on the basis of which, if and when the possible effects restrictive of competition are or are not inherent in the pursuit of the objectives aimed by FIFA and UEFA. As you see, this is finally not written in detail in the treaty, but in my view is the best reading for applying Article 65. And it is a very operational way of reading the article. Finally, it's not just a declaration. It's something with practical implications for the application of the treaties. Having come to this point, I have just a final question, which remains also to be considered. And it's the question that has been mentioned so far during the last panel of the proportionality of the measures at stake. The proportionality to the extent that they may be liable to produce anti-competitive effects forget the anti-competitive object of these rules, these particular rules that we are dealing with in this case. Proportionality, the proportionality test to be made to the extent that those rules may be liable to produce anti-competitive effects or are not based on objective, transparent, and non-discriminatory criteria, or are deemed to be excessive. I think that with the already mentioned exception of the sanctions applicable to players not involved in the project of a breakaway league, the concrete measures under debate are necessary, and I'm following the opinion of the Advocate General, are necessary, appropriate, and proportionate to the legitimate objectives they pursue. Why? Mainly because they do not prevent the creation of any independent league and are merely intended to prevent dual membership, where the promoters of a new competition not authorized by a European governing body simply want to secure for themselves the best of two worlds. And I think this is legitimate. In addition, the promoters and funding clubs of a breakaway league and many of their star players have important financial resources and a degree of autonomy that gives them considerable bargaining power and a degree, I would say, a large degree of autonomy in deciding to set up a rival European competition outside the FIFA-UEFA ecosystem. This is not only a theoretical possibility, it is a practical possibility. They have the means to do it. If they don't do it, it's because they don't want, or they finally recognize that it's not easy. Be it as it may, I do not think, and this is a slight twist that has not been made so far. I didn't yet see it written. I do not think that any proportionality test should be left to the discretion of national courts, as Advocate General Rand suggests in different occasions in his opinion, both in direct actions for annulment, as in the International Skate Union case, and in references for preliminary ruling, as in the ESL case. It is, in my view, for the Court of Justice itself to carry out the test. In such cases, what is at stake, is not the proportionality of any domestic rule of a member state. It may vary between the member states, of course. Each one has its own regulations. And for those, for assessing the proportionality of those rules, the national court is generally the best place to do it. It's normal that the Court of Justice refers the final test of proportionality to the referring judge, because it's closer to the facts of the case and to the application that it has to do of the national law. But here it is a different thing. At stake is an assessment to be made on the proportionality and compatibility with EU law of rules adopted by interstate bodies involving European competitions with a global or European dimension. I don't see how those rules could be uniformly applied if the proportionality test was referred to any national judge. So those rules must be given a uniform interpretation, which only the Court of Justice can ensure. And it is nothing new, because the Court of Justice, when it feels the need to do it, it does it. It performs the test, and generally it refrains from doing it. But when it is really important, the court itself gives, in any case, all the indications to the national judge on how to apply the proportionality test. And I think it is the case here. Within this framework, it is finally possible to reach a balance between sporting and economic and financial interests, capable of preventing the latter from hijacking an activity which has a profound economic, social, and educational impact on the fabric of European society and its regional cohesion, while at the same time safeguarding the health of athletes and the fairness of the practice of sport. It remains to be shown, let me put the thing this way, it remains to be shown that these objectives and values can be achieved within the framework of a closed system based on profit, which reserves places in the competition for the most powerful of the powerful, and which represents a fundamental rupture in the European institutional and social framework that has been painstakingly built up over decades. Now, just a final remark, inspired by previous panels. Please do not expect the court to answer all the questions that this system may raise, and questions that have also been raised here during this conference. The court and its role will answer the questions that have been put to it by the Spanish court. It will not go further than the scope of those questions, even though it is also used to refine the questions to give the most useful answer to the national court or to foster some options of judicial policy. That's the way the court works. It comes case by case, and the court sees the opportunity to set new principles and to make steps forward in the progress of EU law when it is given the opportunity to do so. Thank you very much for your attention.
Thank you very much, José Luis. I won't be too long because I think that the afternoon has been intense. Just a couple of words to finish this conference. Just to say that independently of the decision that will be taken in a couple of weeks by the European Court of Justice, we have been discussing a lot of issues today, and one is really and very important is that even if we have a favorable decision regarding the current model, is that many things could be done to improve it and to strengthen it, especially regarding solidarity and redistribution. I think that these are two key topics that all governing bodies, sport governing bodies, should work on. So probably a piece of actions for all the governing bodies. And we will see what the court decides at the end of the day. Just a final words of thanks. Thanks to you who has been attending this conference either here in Luxembourg or online on YouTube. It has been a real pleasure for us to organize it, sometimes a bit intense too, for some of us. So many thanks to everybody that has been involved in the organization of this conference, especially the CDES team. Thanks also to our partners on the technical part of this conference, Momentum Production for the broadcasting, and also Sport Plus advice, for the organization on a logistic point of view. And also many thanks to our partners. I will thank and name them once again: the University of Limoges, the University of Rijeka, in Croatia, the University College of Northern Denmark, Sport&EU, the International Association of Sports Economists. It has been a pleasure to have been working with you, and your suggestions about speakers and all insights has been very, very helpful. Thanks to all the speakers involved today. Thanks to Marine, because it was perfectly moderated. Thank you very much. And yes, maybe we'll meet you in a couple of months to discuss the final decision and to see what happened then. So let's try to see in, I don't know, 2, 3, 6 months or later. Thank you very much.